everyone. Welcome. Sorry for the late stream, but I just was not on my game today. We got Kouri Richins, day 11. If you can call it day 11, it's done at least. The defense, they're an absolute joke. They're asking for, they wanted a 2-day recess at one point today for all the stuff that they should have been working on the last week, but it's all out of court or out of jury present stuff today, discussing the walk the dog letter, Kouri's interviews, her stupid texts, one text where she says she thought she'd be set for life if he died. And then back to the Carmen Lauber testimony or whatever. So we will review all that. I've got it condensed down to about an hour's worth of video. For those of you who are just joining us for the first time, though, this is a commentary channel. And those of you who don't know what commentary means, it means I'm going to talk a lot. I'm finally looking at the camera. Also, well, it comes to commentary. If you find that something I make a joke about isn't necessarily funny to you, that's okay. But telling me it's not funny isn't going to make me think it's not funny. And think about all the other things in the stream that you've laughed at that you do think funny, but oh, this one thing's off the limits to you. Not saying you're not welcome here, just saying don't even bother having the discussion with me. I'm still going to think it's funny. But if you do enjoy what you see here, consider hitting the like button and subscribe so you can check out the mini playlist of the video below, or playlist in the description of this video below, such as Sarah Boone, Lauren Armstrong, Diane Downs, others, including Robert Tellis, and now, of course, Kouri Richins. So hello to the live chat. Hello to everyone in the replay crew. Let's get this thing started. All right? Yeah. Cut the sugar plum fairies there. All right. Let's see here. So first up, what was the first part? What we had to discuss? My notes. The Kouri interview. Now, the point of this is the defense wants it in because it's a lot of self-serving hearsay. The prosecution doesn't want it in because it's a lot of self-serving hearsay. Let's see.
Ms. Nestor, I appreciate the email you sent earlier this morning. Should we start with the O'Driscoll interview?
Okay.
Does that make sense?
Yes, sir.
Okay, this is docket 1163, which is the state's motion regarding portions of the O'Driscoll interview, as clarified by docket 1555 and...
Absolutely. All this stuff, they're treating it like this is an 11th hour surprise. They should have had... I'm surprised a lot of this stuff wasn't already set in pretrial definitively.
Ms. Nestor's email of this morning. Let me get there with you. And I left both of those items on my printer. I'll be right back. You can stay seated. Thank you.
Nice, heck, Jess.
Have a seat. Thank you. Okay, Ms. Nestor, with respect to pages 1 to 7, what's the value in, or I guess more accurately, under Rule 106, how do pages 107 qualify, explain, or place into context the stuff that follows?
It's always great when the judge starts off, what is the value of what you're trying to do?
Mainly because he gives the reason why the whole interview is like what he's doing there and why the interview is happening from his perspective. And I believe that's important to put the whole interview into context. I don't see there's anything at all objectionable in it. And it does provide a context of how this meeting happened. They're not in the police station. They're in her house. She invited him in. She voluntarily met with him. All of that, I think, matters to context. And we're asking that it come in, especially because there's nothing in it that's...
I don't understand the defense's stress on the point that Kouri voluntarily talked to detectives sometimes. Of course she did. She's trying to manipulate people. And guess what, ma'am? A lot of murderers do talk to detectives willingly. They turn down lawyers. All that crap.
Controversial. And there are things I think that are very helpful.
Mr. Lauber.
Your Honor, there's a distinction between context, the interview, and context to particular statements. And while this provides context to the interview, it provides no context to kind of any of the 6 individual statements. The interview context can be sufficient drawn out through examination of Jeff O'Driscoll. I mean, I'll lay a lot of some of that foundation before I introduce any of the statements, and then of course he's subject to cross on that. The other thing is this is peppered with the defendant's self. That state holds the keys.
Okay, so we're going to do this one chunk at a time. The standard under Rule 106, and it's not discretionary, it's an on or off switch, is whether the portions that, in this case, the defendant wants to add to the designations made by the state are necessary to qualify, explain, or place into context the portions of the interview transcript that the state seeks to introduce. That's under cases like State versus Cruz Meza, 2003, Utah 33, at paragraph 14. Here, with respect to pages 1 through 7, I'm persuaded by the state that this context for how the interview occurred will come out through direct and cross-examination of Detective O'Driscoll. These 7 pages are not necessary to qualify, explain, or place into context any of Kouri Richins' statements that follow. Okay, so we're not going to add 1 through 7. Those will stay redacted. Then we get to pages 15 to
defense loses
16, right, Ms. Nestor?
Yes, sir.
Okay. This is new as of this morning. Give me just a moment. Do you have a specific line number?
Oh, and for those who are confused by the thumbnail, because it says idiots everywhere and I'm in the middle there, question, does that mean I'm an idiot? Yes, I'm an idiot as well. I'm an idiot because I'm watching this.
Just the redactions that are on both pages, we would like unredacted. So it starts at line 10.
There are no redactions on those pages.
I have redactions on lines 10 through 25 on page 15 and lines 1 through 12 on 16. It's the copy I was given.
Your Honor, in negotiating this back in whatever, January, the state conceded to her request to unredact that. The state unredacted it. The current copies, which are before the court and in the link I recirculated this morning, show no redaction.
Okay, that's moot.
Update your files, people. Why is this? Not only do they ask bad questions that they don't know the answers to, irrelevant questions that elicit testimony that damages their client's case, why are they always behind the 8 ball or behind on getting things read, reviewing them? It's like they just read the first 2 pages of something and then go, okay, got it.
Very good. That brings us to pages 29 to 32.
So, for example, here, when reviewing stuff on sidebar or not sidebar, when reviewing stuff for admission, go ahead and make sure you have the actual accurate, up-to-date copy for your own client's sake as well. What if it was the opposite way? What if there were what if there were redactions? The redactions that you had before and now they're not because you forgot that the prosecution won something, and then all of a sudden it's in. You look like a big idiot.
So here we have Ms. Richins making references to Eric going to jail and Cody's involvement in that situation. Ms. Nestor, why is this necessary to qualify, explain, or place into context Ms. Richins' statements in other parts?
Also, I don't understand what is the point of the argument with the jail, with the hunting between Cody and Eric. Are they saying Cody killed him?
Give me just 1 second, Your Honor.
Sure.
So previously, they were talking about whether or not Eric was happy, if he was depressed, if he was suicidal.
Oh my God. This shit.
And as a flow and arc of that conversation, she then goes into the question O'Driscoll asks is, okay, anything else regarding his mental health history? That's line 3 on page 29.
This again screams desperation for the defense. Their original theory they wanted to get in with the Red Devils or whatever is not working. So now I think they're going to switch towards suicide?
She answers no, not really. But then she goes into like there wasn't generally, he had his struggles. He was stressed. And then she explains how he was stressed. So I think or why he was stressed about his relationship with his business partner. I do think that completes the answer to the question. It completes the entire subject matter of the conversation. It's actually evidence that has already come in as far as no longer being objectionable. This all came in Cody's testimony. So we would ask that it be put back.
So I think you have fairly characterized everything through page 31, line 3.
Oh, man. If you fairly characterized up until a point, that means afterwards you didn't.
Though, I think he turns in a different direction. That is not relevant or does not qualify, explain, or provide context for what you just described.
I really don't care about the rest of it.
Mr. Bloodworth, line 29, page 29, line 5 through page 31, line 3.
So we will unredact.
I think it's a fair continuation of Kouri's explanation regarding things that were stressing Eric Richins.
Yes.
Okay, very good.
Okay, so the defense gets a big win there, I guess.
So we're going to unredact page 29, line 5 through 31, line 3. The remainder of that redaction stays at. All right, I think then we go to pages 107 to 112. Help me out, Ms. Nestor. I wasn't quite following defendant's position.
Okay, just 1 second, Your Honor. I'm sorry. So this, and it's getting hard for me to remember what I know.
For those just joining us, they're talking about the interview that Kouri had with Detective Driscoll and what part of that transcript is allowable, permissible when Detective Driscoll is interviewed or on the witness stand talking about the interview.
From what happened in the courtroom versus what I know from getting ready for trial, so I apologize. I cannot remember if this came in yet. I think it's going to come in with Mr. O'Driscoll if it hasn't already with Chelsea, but there's conversations in here about texts with Chelsea on the day that Eric passed. And it's a continuation of O'Driscoll about phone and him reviewing available phone records. And she goes into what she's reviewed in terms of the calls between her and Chelsea. So I do think it's all part of one conversation. And I think to the extent that hasn't come in yet, I think it's going to come in today.
Well, I don't disagree with your prediction about what Detective O'Driscoll might testify to. The task I have to engage with here is whether any portion of 107 through 112, line 9, is necessary to qualify, explain, or place into context Ms. Richins' other statements in this interview.
So I think it's a direct continuation of the questioning above it about telephone records and whether she has available phone records, and she discusses these records of calls with Chelsea. So I do think it's all one conversation.
Can you point me to specifically? It seems to me that the preceding pages there talking about what phones she had access to during what periods of time, when those devices were or were not available to her, which belonged to C&E, which belonged to her.
If you go back just a little further, Your Honor, to page 105, line 15, Detective O'Driscoll starts with, okay, so when was the last time before the night of the 3rd that you talked to Chelsea? Do you think it was the 2nd? And she says, I think it was the 2nd. And he says, when you guys were talking about the anniversary, do you know for sure if it was the 2nd or 3rd? Kouri goes into, well, yeah, because actually she sent me all the text messages because they were saying Woody tried to tell Chelsea, which was not true, that Chelsea's the last person I talked to. That's absolutely not true. And that there was some kind of message or something the night of the 3rd. I don't know, but we've pulled all phone records and Chelsea still has messages on her phone. So none of that is accurate. And then it goes into, do you have those records?
I got to hear this part again.
Saying Woody tried to tell about the anniversary. Do you know for sure? Starts with, okay, so when was the last time before the night of the 3rd that you talked to Chelsea? Do you think it was the 2nd? And she says, I think it was the 2nd. And he says, when you guys were talking about the anniversary, do you know for sure if it was the 2nd or 3rd? Kouri goes into, well, yeah, because actually she sent me all the text messages because they were saying Woody tried to tell Chelsea, which was not true, that Chelsea's the last person I talked to. That's absolutely not true. And that there was some kind of message or something the night of the 3rd. I don't know, but we've pulled all phone records and Chelsea still has messages on her phone. So none of that is accurate. And then it goes into, do you have those records? They were talking about subpoenas. Do you still have them? And then they start redacting her explanation of how she got these texts and basically that she's looked at them and what they say. So I think you're cutting out the second half of that conversation, which to us is misleading and we'd like it all in.
Your Honor, may I offer a suggestion?
Yep.
The state proposes to redact page 105, line 15, all the way down through 107, line 11. So redact the entire portion as it relates to Chelsea Barney.
Okay, that removes the necessity of what follows, Ms. Richins. Ms. Yes.
It does, except that I think they'd have to go back further to, because they still have up there where Detective O'Driscoll's basically saying it's weird that your conversations with Chelsea's are deleted. So, I mean, they're just picking the part they like and taking out all the rest of it, right? So they'd have to go back further. If they really want to take out everything about this, it would eliminate my objection, but they'd have to go back to, let's see.
So why don't we go up to 105, line 3?
Okay, let me look at that.
The state still gets the general question on page 104 into 105. It just doesn't focus on Chelsea.
That would fix my objection because then it would just take all of it out.
Well, you're,
For example, just so the record is clear, because we only have an audio record here, we have Detective O'Driscoll asking about whether is it possible things were deleted on your phone? And Ms. Richins saying at 104, line 20, yeah, that's just not possible.
Right.
It's okay, I was on the phone. What did I miss? Back it up again. Back. Sorry, we got to hear it a third time.
Detective O'Driscoll starts with, okay, so when was the last time before the night of the 3rd that you talked to Chelsea? Do you think it was the 2nd? And she says, I think it was the 2nd. And he says, when you guys were talking about the anniversary, do you know for sure if it was the 2nd or 3rd? Kouri goes into, well, yeah, because actually she sent me all the text messages because they were saying Woody tried to tell Chelsea, which was not true, that Chelsea's the last person I talked to. That's absolutely not true. And that there was some kind of message or something the night of the 3rd. I don't know, but we've pulled all phone records and Chelsea still has messages on her phone. So none of that is accurate. And then it goes in.
What? Is this the detective talking or is it her talking?
Woody tried to tell Chelsea, which was not true, that Chelsea's the last person I talked to. That's absolutely.
Woody tried to tell. Oh, Detective Woody.
Do you know for sure if it was the 2nd or 3rd? Kouri goes into, well, yeah, because actually she sent me all the text messages because they were saying Woody tried to tell Chelsea, which was not true, that Chelsea's the last person I talked to. That's absolutely not true. And that there was some kind of message or something the night of the 3rd. I don't know, but we've pulled all phone records and Chelsea still has messages on her phone. So none of that is accurate. And then it goes into, do you have those records? They were talking about subpoenas. Do you still have them? And then they start redacting her explanation of how she got these texts and basically that she's looked at them and what they say. So I think you're cutting out the second half of that conversation, which to us is misleading and we'd like it all in.
Okay, so what it sounds like, it wasn't, so the detective is saying we don't have these messages and Kouri's saying, no, we do, absolutely, because we copied Chelsea's phone. And then the detectives are like, well, can we have copies of that? I think.
Your Honor, may I offer a suggestion?
Yeah.
The state proposes to redact page 105, line 15, all the way down through 107, line 11. So redact the entire
jury is not
relates
in
to Chelsea
the
Park.
courtroom.
Okay, that removes the necessity of what follows, Ms. Richins. Ms. Nestor.
It does, except that I think they'd have to go back further.
Oh, take a win, defense.
To, because they still have up there where Detective O'Driscoll's basically saying it's weird that your conversations with Chelsea's are deleted. So, I mean, they're just.
But we know that they're deleted. What is the point, ma'am? Stop reminding the jury about what my client did.
Picking the part they like and taking out all the rest of it, right? So they'd have to go back further. If they really want to take out everything about this, it would eliminate my objection, but they'd have to go back to, let's see.
So why don't we go up to 105, line 3?
Okay, let me look at
The
that.
state still gets the general question on page 104 into 105. It just doesn't focus on Chelsea.
That would fix my objection because then it would just take all of it out.
Well, you're,
I cannot fail.
For example, just so the record is clear, because we only have an audio record here, we have Detective O'Driscoll asking about whether is it possible things were deleted on your phone? And Ms. Richins saying at 104, line 20, yeah, that's just not possible.
Right, and then he gets into Chelsea's.
That's not good. We're talking about Kouri's cell phone, the one which absolutely had everything deleted for months.
Starting on page 105. So, right, if they would delete from 3.
Yeah, I am curious about that too, Liz Larson. What is Kouri writing this entire time? Because she's looking at one legal pad here and then writing on another one. I think, is it another novel?
Of 105 all through all of it, then that eliminates my objection, because then they're not just putting in half of it, not the other half. But I would withdraw my objection under those circumstances. If they want half of it in, I want all of it in.
Okay, Your Honor, I think we're narrowing in on this, but I don't think we're there yet.
Okay.
I think the defendant raises Chelsea, right? And at page 105, line 8, it wasn't.
Yeah, you're probably right, Blue Giraffe. She is filling out more loan applications.
Detective O'Driscoll. So I think the redactions should begin.
Oh, I see your point.
At
line 15.
Right.
She's using recovery of information on Chelsea's phone as an explanation for why she wouldn't bother to delete anything.
Correct.
Okay.
And I think there's a.
Well, that's a good lie, huh, Kouri? Why would I delete everything if you could just get off my friend's phone? Because you didn't think the police were going to check?
Distinction between right here, I think at line 15 is the tipping point where there is a statement about deletions,
right? And
then at line 15 it tips into a discussion about text messages with Chelsea in particular.
That's fine, Your Honor, if you want to start at line 15.
Okay, so we will add the following redactions. We will redact line.
You know what she could be doing? Okay, Meow Meow says maybe her closing statement like Sarah. No, what I think she could be doing is writing out the answers she is going to memorize for when she's on the stand. All this damning testimony.
Line 105, page 105, line 15 through 107, line 11. And that resolves defendant's request to unredact pages 107 through 112, line. Scott, I went kind of fast there. Did you get that?
Yes, Your Honor.
Okay, very good. All right. Anything further on that, Mr. Glover?
No, sir.
All right. Through 107, line 11. All right. That brings us to page 120, line 24 to 121, line 8. This is Kouri Richins giving Chelsea's phone number to Detective O'Driscoll. I didn't follow how this relates to a prior state.
Just 1 second, Your Honor, I'm sorry. So all this stuff above that is redacted, right?
Yeah.
Okay, just a minute. I'm getting a little bit lost. Just give me.
Oh, are you getting a little bit lost? You're always lost. You were never found, Nestor.
Let me look at it more time. So right now we're looking at the line 24 through 121, line 8.
Please.
Okay, I got it. Just wait. This may not apply anymore now that Chelsea's testified, but let me just we'll withdraw that one, Your Honor.
Okay, then let's go to page 125, lines 6 through 16. I genuinely don't know why defendant wants to unredact this. We have worked real hard to keep this.
Yeah, we'll withdraw that one.
What was it? I want to know what she wanted to have unredacted. The judge, I genuinely don't know why you want to unredact this.
Then we go to page 133.
I'm guessing it has to do with the fight with Amy in the punch.
Beginning at line 12. And it goes through 141.
Okay.
My notes reflect that this is a discussion regarding law enforcement officers and Cody Wright taking all computers related to C&E and maybe some others, and Cody having access to the garage and office at the Richins home. How does this qualify?
What was that? Sorry, I was reading.
Taking all computers related to C&E. 41.
Okay.
My notes reflect that this is a discussion regarding law enforcement officers and Cody Wright taking all computers related to C&E and maybe some others, and Cody having access to the garage and office at the Richins home. How does this qualify, provide context for Ms. Richins' other statements?
Well, it doesn't, Your Honor. The thing is, they really want it in because it throws some shade on Cody instead of Kouri.
Trying to see where their actions start and end on either side. So is everything after 141 redacted still? I haven't seen the newest version. Everything after what?
No, there's some unredacted portion beginning page 167.
Good night, Margarita. If that's what I read it, you're going to sleep. You can go to sleep.
The statement before this redaction that we're discussing is the defendant's statement as it relates to life insurance.
Yeah, you might have just ate some PCP Unicorn Rancher. I would. If you're not feeling better and out, you can go to the hospital.
Still on the, I haven't seen the newest version. Everything after one.
No, there's some unredacted portion beginning page 167. The statement before this redaction that we're discussing is the defendant's statement as it relates to life insurance. The statement after this redacted portion we're discussing is the defendant's statements as it relates to the trust. And the piece that we're redacting relates to collection of C&E computers, which in the state's view under 106 is not context to either the preceding or the subsequent statement.
That looks accurate based on my review.
I think most of this has come in now, so I'm just making sure that there's nothing. Almost there. One more second. There's quite a few pages. That's all come in, Your Honor. We don't need it anymore.
So defendant's request to add pages 133, line 12 to 141 is withdrawn. Then we fast forward to page 174 through 184. Here, Ms. Richins is talking about the party's joint account and the flow of money from C and her real estate business through various accounts.
Right.
The immediately preceding statement is regarding the trust. The immediately following colloquy seems to be about life insurance.
Yeah, just a minute. I also think most of this has come in. If you can give me just a moment, Your Honor.
Sure.
There is no break at 141. The redactions are.
I think that all came in, Your Honor. We'll withdraw that.
And then finally, page 230, line 25 through 215, line 6. This immediately follows a statement by Ms. Richins regarding Eric knowing about the HELOC. And
it's funny because whenever they say, I think that already came in, they're basically saying stuff that they had hoped to keep out. They weren't able to do that. Now, I'm curious as how many times that was brought in by themselves.
And consulting a divorce attorney and him knowing about that based upon statements made by his family members. I'm not sure. Forgive me. I misstated that. It immediately follows a statement by him about knowing about the HELOC. And then Ms. Richins talks about how he knew about that was because his family members told him, and then he went and consulted with a divorce attorney.
Right. I do think that's all one conversation, Your Honor, where they're talking about how he, I gotta go back a little further. They're trying to say what they're accusing her of and how they change. I mean, that's all one conversation, I think. I stand on that request.
Tell me why Ms. Richins doesn't pivot away from what Eric knew to what his family members were doing to her. There seems to be two different topics here.
Well, I think
it's all what the family members are doing to her.
this is all connected to the HELOC. I mean, Ms. Benson testified early on in this case that the HELOC was what precipitated the meeting with the divorce attorney. The divorce attorney has also testified to that.
Right.
This is Kouri lumping all that together in one conversation with O'Driscoll. So I do think this all should come in context. I just think it's all connected to the beginning of the conversation where they're saying that he was unhappy about the HELOC and that he had been meeting with someone about a divorce and that Kouri was unaware of that and that she learned about that later from the family. So I think that's all connected. I would ask that come back in.
Should have thought. Is the reason they keep bringing up the affair to try and argue that the reason Eric went to the divorce attorney was because he was having this emotional affair, or now, based on yesterday, he's actually secretly gay? Yeah, I don't know. What do you guys think?
Your Honor, the precedes the statement the state seeks to isolate is the defendant's statement regarding what she knew about the HELOC. In the redacted portion, she then pivots to divorce attorney discussion, which is in her statement separate and distinct from the HELOC. It has come out in trial that the two are connected, but in this state, it is a distinct statement through the court.
Just in terms of that, it seems that Ms. Richins sent.
Well, Libby, yeah, she saw a divorce attorney too, but that's only after she found out that Eric had, and plus she was having an affair.
That begins on 213.
Is bringing up Kouri's affair or Eric's affair to somehow, soften the fact that Kouri was actively having an affair? Bring up the emotional affair is like, well, nobody's perfect. Every marriage has its ups and downs. I would say he could have been secretly bi. I don't think there's anything to the text with Bryce, but it bothers me no one has mentioned he could have been bi, the erasure of it all. Right. That's what I was confused. How are you arguing? Well, I guess they didn't say bi, but I mean, they did not say bi, I guess. So, yeah.
2 doesn't actually end until 214, line 2. It looks like maybe she and Detective O'Driscoll talked over each other in that point. It would seem appropriate to end it there and then redact it. So just to unredact 213, line 25 through 214, line 3.
Agreeable.
Okay, that's the court's ruling, isn't it?
Understood.
So we're going to unredact page 213, line 25 through 214, line 3. Okay. I think that handles the parties' positions regarding the transcript of Detective O'Driscoll's interview with Ms. Richins. Mr. Bloodworth, anything else on that?
No, Your Honor.
Ms. Nestor?
No, sir.
Okay, so that brings us to the jail calls. This was originally filed.
All right, the jail calls of Kouri. Moron, always talking on recorded lines, always recording herself.
This docket 1165 by the state. It's further characterized by docket 1555. We're just going to have to go through these one at a time. As a matter of mechanics, Mr. Bloodworth, these will come in through Detective O'Driscoll.
Yes, Your Honor, as a matter of mechanics, and I don't know at this point if we're going to introduce them all through Detective O'Driscoll on direct. In fact, I recall there may be only one or two that I can pin down that we may want to address first, although I think that we can't resolve the whole set of them today because I can see how it would come the redirects and some crosses that would could begin as early as today.
All right, let's go through them. So tab, well, I don't know if you have the same binder. Let's go 2-69T.
Your Honor.
And my main concern is on page 8, lines 6 through 18.
Sorry, Your Honor, I'm just pulling it up. Which one are you looking at? Can you give me the number again, sir?
2-69T.
Okay, got it. And what portion are we looking at?
Well, the court's concern, based upon the content of the unredacted portions that the state seeks to admit, is page 8,
Lines 9 and
especially. Yeah. Although,
Oh, that's definitely part of it. Well, that's Carmen being in jail, right?
Yeah, she's not in jail.
yeah.
Oh, well, she's
the
not.
only way Ms. Richins would know she's
Right.
not there is because she's there.
Wow. Defense attorney, you can't follow that argument. You had to have that laid out for you. So in this call, she's mentioning how Carmen is not in jail. The defense attorney is like, so? Or Carmen is in jail. Defense attorney is like, what's the problem with that? That's about Carmen. Well, the only way Kouri would know that is because she's in jail. Idiots. They're helping her be less stupid.
Right.
So yeah, Your Honor, we can certainly redact line 9 and 10 there. We can redact 11. I don't.
Yeah, if we can do 9, 10, and 11. Yeah.
Yeah.
Okay.
Well, it's a community property estate, but that doesn't property state, but that doesn't matter when there's a prenup and then a trust in place for the assets they had before the marriage. She doesn't get any of that.
Nestor, what was defendant's objection to the remainder of this?
Hold on just a minute, Your Honor.
So, Brittany, from 2-69T, we're redacting page 8, lines 9 through 11.
I think that was my objection to this one.
Okay.
Let me just make sure. I think that was it. I think that was the only problem I had with that one.
Very good.
Wait, hold on. That's Carmen.
Okay.
Yeah, that's it, Your Honor. That was my objection.
Very good. Let's go to 2-71R. There's only 3 text messages sent from the jail
I'm
system.
sorry, Your Honor. Oh, never mind. They redacted it. Okay, I apologize. Please continue.
2-71R.
Get to the text. Get to the text.
These are text messages sent from the jail system.
Man, she's not even satisfied with just recorded calls. Let me send some digital text too.
The state seeks to admit 3.
You want a side by? Basically, this whole day is a side by.
Right?
Yes, sir.
It's the ones from May 24 at 9:50, May 24 at 10:02, and May 24 at 10:03.
Correct.
Okay.
So we have a couple of objections to this one, Your Honor. It looks like they have made all the redactions that we require.
They do discuss walk the dog here, but I'll spoil it for everyone. Nothing really happened in front of the jury today. This is all discussion about what's going to be in front of the jury. Many things that they've discussed before the trial, but that's all this is. And then the defense for the temper tantrum.
Requested that indicate it's jail related, so that those have been resolved. However, this is a correspondence between Kouri and her brother, and the brother's asking her, did Eric ever talk about suicide?
Right.
And she's repeating things that Eric said to her, which would be hearsay. Also, I believe the brother's statements are hearsay.
Well, all of the non-Kouri Richins statements are going to be hearsay if they're accepted for the truth of the matter.
Right.
So that's...
Well, but they're specifically trying to admit what Eric said for the truth of the matter. So that's the concern that I have. She's like double hearsay. I know Kouri's statement isn't hearsay, but when she relays what Eric told her, that is hearsay.
No, it's not. It's not, because it's a lie. I don't know if they say the actual statement, but if Kouri is saying, "Oh yeah, Eric was suicidal," but that is, not supported by anything else, that is a lie, and it can be used to impeach the witness or impeach Kouri.
Well,
and if Kouri says it is true, she can get up on the old stand.
All of the non-Kouri Richins statements are going to be hearsay if they're accepted for the truth of the matter.
Right.
So that's...
Well, but they're specifically trying to admit what Eric said for the truth of the matter. So that's the concern that I have. She's like double hearsay. I know Kouri's statement isn't hearsay, but when she relays what Eric told her, that is hearsay. So that's our objection to this one. Also, we just don't see the relevance. There's no...
You don't see the relevance of whether Mr. Richins ever spoke about suicide?
I don't think either side is making the allegation that he intentionally killed himself. That's never...
Right. We're eliminating it. Dingbat.
been said by either side.
I think the state is seeking to prove affirmatively that he did not. So I think we can put...
You're right, Your Honor. That is exactly what the state is seeking to prove. But he definitely did not kill himself.
Relevance aside, it's certainly relevant.
Okay.
Mr. Bloodworth, talk to me about the hearsay. Put the brothers level aside. It's the truth of Eric's statements to Kouri as related by Kouri. Kouri's level, categorically not hearsay. It's the Eric Richins level. Let me pose a hypothetical to tease out the legal issue. It'd be one thing if, I guess what we're trying to tease out is whether this is evidence of whether Kouri ever heard Eric say it versus whether Eric ever had suicidal ideation.
So I appreciate that distinction, Your Honor. She doesn't quote him, right? It's a generic, this is my impression of generally...
Of my husband.
Right.
Well, respectfully, I disagree. He would always say things like, if anything ever happened to me, blah, blah, blah. I mean, if they want to redact...
If anything ever happened to me, that's not a suicidal statement. You know what? I told my wife, if anything ever happens to me, you got the life insurance. Here it is. I have life insurance through my company. That's not saying in case I kill myself.
Everything after the word, not suicide specific.
And you could argue, then, following that conclusion, that going to the estate attorney means he was concerned about dying. Not suicide, though.
Specifically, then my objection, apart from the relevance, which I stand by, but that would cure the hearsay problem of what he actually said. But they could leave in her answer not suicide specifically, because I don't think that relates to a particular statement. It actually refers to the absence of statements.
I think the opposite. That is what explains her statement, not suicide specific.
Well, then none of it should come in.
Right. The statement, Kouri Richins' statement is not suicide specific. The remainder of that particular text is, in a sense, 106 completeness because she is explaining her statement.
Why don't we just instruct the jury that they can't accept Ronnie or Eric for the truth, but they can accept them for the effect they had upon Kouri Richins and let the whole state.
Correct, Your Honor. That's appropriate.
Because
Yeah, there we go. That would do it. But defense, you don't like that either?
it's not being offered to show any effect on Kouri Richins. It's being offered to get in the fact that Eric made that statement to her. That's the whole reason this is coming in. And I stand by my objection, Your Honor.
And just to be clear, you don't want to admit the statement that Eric told her they'd be set for life if he died.
No.
Okay. All right.
You don't want to admit the statement that you'd be set for life if I died. I don't understand why. Why would Kouri telling your brother, Eric said I would be set for life if he died? Why would that matter?
Yeah, I guess if the statement Eric made isn't true, what relevance does it have, Mr. Blake?
It explains Kouri Richins' statement, not suicide specifically. It is the effect on Kouri Richins to respond to the question of did Eric ever talk about suicide? She said not specific, explains herself. So the foundation for her statement, it is what the effect of Eric's statements on her.
Right. But as we tease this out, it seems that to the extent that the effect upon her was relevant, regardless of whether it was true, it was her understanding that she'd be set for life if he died, not whether or not he had suicide. Is that fairly stated?
Your Honor, the state thinks it's both, actually. It is the set for life. He died. It's certainly that, right? But it's also the suicidal ideation part because, evidence will come, I think, come in that she never believed. She said he would not in other portions of
well, and at her level, that can come in, right?
Sure, but there's a foundation for that. Why do you believe?
I think with respect to this particular text exchange, first of all, I don't understand why we need the third point work backwards. Why do we need her brother saying, just curious, someone threw out a scenario, that seems to be a throw.
Well, I guess it all depends on whether or not DJ tests.
Forgive me.
That that statement could be used in impeachment of DJ Kouri if he were to test.
Is this one of the things that's coming in through the state's case in chief or the rebuttal, or through cross? My apologies. As yet unclear.
So, yes, Your Honor, that'd be perhaps resolve, I think, the current tension.
Yeah.
If it comes in the state's case in chief, then I would agree that third statement we could redact. We may have a discussion down the road about unredacting it.
Understood. Okay. So focusing on the first two, I think the correct result here, let me state it and then let counsel ask for any clarification, is to admit the first two text messages with the following instruction to the jury, that they cannot consider Ronnie's statements for the truth of the matter only for the context that they had or the effect they had upon Ms. Richins as the listener. They cannot consider Ms. Richins relating what Eric Richins told her for the truth of whether he ever had suicidal ideations or whether she would actually be set for life if he ever died, but can consider it for the effect that that statement by Eric Richins had upon her on a going forward basis.
What, can we just get a statement as to what effect that did have on her? Because I don't understand that argument at all.
She thought she would be set for life if he died. It provides a...
How are you not following this, Gungan? Wait. Well, but what effect would it have had on her? Like, can we clarify? This is such a stupid question. I mean, obviously, I don't think they believe it themselves, right? But is this just like one of those things like, can you clarify exactly how are by this statement? And what level we are?
I don't understand that argument at all.
She thought she would be set for life if he died. The truth of whether he ever had suicidal ideations or whether she would actually be set for life if he ever died, but can consider it for the effect that that statement by Eric Richins had upon her on a going forward basis.
What, can we just get a statement as to what effect that did have on her? Because I don't understand that argument at all.
She thought she would be set for life if he died. It provides a... Mr. Bloodworth, any clarification?
No, Your Honor.
Okay. Any other clarification, Ms. Nestor?
No, sir. We just would like a continuing objection to that one.
I don't know.
So I don't have to, when they admit it, I won't have to jump up. I just like...
And you don't, under Rule 103, have we discussed anything further on that?
No.
You don't want to draw attention to it in front of the jury that you really think it's bad, right? You're hoping to fall asleep. You just take a little nappy through that one, jurors.
Okay, Scott,
Yes, Your Honor.
would you initially redact the message from Ronnie at 5:24 at 10:03? Just curious. I watched something that said her.
I think it's from DJ.
Oh, I'm sorry. You're right. Threats from DJ. For now, I can pause for a second if my description was inappropriate.
We're getting it. We're tracking it in the back as well.
No problem. Sounds good. Okay, moving on. That brings us to 272R. As I understand it, it's five text messages from 5/31/2023 at 7:14 to 5/31/2023 at 7:24. I think the relevant part of this, Mr. Bloodworth, is that Ms. Richins saying she hardly knew Hayden Jeffs. Is that the point of this?
Correct.
Okay. And so do we need anything after the 5:31 at 7:22 where she says...
So you're referring to the last two of those texts?
Yeah.
We can redact those.
Okay.
Wait, I'm sorry. Which ones? I missed which ones you're talking about right then.
Another one wanting their 15 minutes of fame. Oh, God.
I would object to that coming out. I object to this whole thing coming in, but if it comes in, they should all be in.
All right. Tell me why you object.
I don't understand the relevance of this at all.
So we have testimony that's come out that Kouri Richins had a telephone conversation with Hayden Jeffs regarding the topic of fentanyl. Here she's saying she hardly knew him.
Hey, did that help connect the dots for you there, Gungan? What are these objections?
Of their relationship.
They don't talk about that at all in here, though, about any conversation that
She talks about hardly knowing.
Your Honor, we just stand on a relevance objection.
Okay. Anything else?
No.
Okay. this is relevant to Ms. Richins' knowledge of or disclaiming knowledge of Hayden Jeff. And do you want the whole thing, Ms. Nestor?
Yes, I do.
All right, we'll leave it as is, Mr. Bloodworth.
Yes, sir.
Okay. All right, tab 7. Sorry, 273T and 274T and 275T. Mr. Bloodworth, Ms. Shervanick, I am genuinely confused by these in terms of this transaction in St. George and this other D. I read them 3 times. I really don't know what they're talking about.
So let me propose this as a way forward.
Yeah.
Today, nothing has come in where the state would. I can see a circumstance where the defendant's mother would testify that the state want to use these in impeachment.
Or the phone conversation.
Or the phone conversation.
Okay.
So maybe we can just put a pin in these till if and when that circumstance arises.
I appreciate that. Any objection, Ms. Nestor?
No, Your Honor.
Okay, very good. We will skip 73T, 74T, and 75T for now. Then we go to 2-76T. With respect to this one, the defendant objects to redacting lines 2 through 8 on page under Rule 106. In the court's view, Lisa making a comment about a corrupt police force is not required to be included under Rule 106, but Ms. Richins wondering if Detective O'Driscoll didn't relate part of his conversation with her to the prosecutor. That seems to provide context.
I wasn't the corrupt police force comment I'm interested in. It's Kouri's, so I don't have a problem with that staying redacted.
So I think if we just focus Mr. Bloodworth on page 7, lines 4 through 8.
I also, Your Honor, while he's looking at that, I did catch on page 7, line 19 and 20. I think that's Lisa reading the information, I'm guessing, and that's the hearsay the court's done an in limine ruling on page line 19 and 20 on page 7. That also, just that one little part needs to be redacted. He later told his friend he thought Kouri tried to poison him. That's been kept out.
Well, that part's come in a couple of times. I think it's the sentence before that's the problem, because that's part of what the state has to prove, right?
Actually, both of those.
I think they both come in.
Forgive me, have we gotten the detail of
The only thing that's come
the
in.
sandwich broke out in hives, had trouble breathing?
No.
That detail has come in, I think, in the context of, Ali Staking's testimony about what they were joking about.
Yeah. Certainly, Ada Sand had a reaction. Was she that specific? I genuinely can't remember.
No.
We can, hopefully somebody in the back scrambling right now to
Take a look.
to get that portion of the transcript. I also think it's coming in a text message as well.
There's the June text message, right, where Ms. Richins is, I forget who the recipient of that text message is.
Chelsea Barney.
There you go. Is talking about, they're saying I gave him a sandwich on that day. And
Right. It's correct. It's the defendant saying, I was with him when he ate. I gave him the sandwich for lunch. He didn't break out in hives. He didn't use an EpiPen.
that's right.
The concern I have also is it says he later told his friend, which is Cody or Case, one of
He
those.
doesn't say that. And we've already got testimony that there was a conversation where she told a group of people that she tried to poison him.
Jokingly.
Well,
This is referring to telling his friend, because his friend was not at that conversation. His friend would be either Cody or Josh, and that's been suppressed.
I don't think that we know to draw that connection, but the jury will.
I don't think we can risk that, Your Honor. I mean, there's a reason you made that ruling. We should stand behind your ruling.
Oh, God. Sorry, I wasn't paying attention to this part. Back it up about 30 seconds.
When he ate, I gave him the sandwich for lunch. He didn't break out in hives. He didn't use an EpiPen.
That's right.
The concern I have also is it says he later told his friend, which is Cody or Case, one of
He
those.
doesn't say that. And we've already got testimony that there was a conversation where she told a group of people that she tried to poison him.
Jokingly.
Well,
Why throw that in? You're not convincing the judge. The judge knows the judge knows Kouri did it.
This is referring to telling his friend, because his friend was not at that conversation. His friend would be either Cody or Josh, and that's been suppressed.
I don't think that we know to draw that connection, but the jury will.
I don't think we can risk that, Your Honor. I mean, there's a reason you made that ruling. We should stand behind your ruling.
No.
I am standing behind it. Let's take this one piece at a time. Mr. Bloodworth, line 7. Can we please add?
Exactly, Rocky. It's a joke. It's all yucks and ha-has about poisoning, but those dick jokes, that is real sexual tension.
Any objection adding back in lines 4 through 8?
Right, page 7, line
Page 7,
4
lines 4
through 8. No objection to adding that back in.
Okay, so we will remove the redaction in 2-76T of page 7, line 4 through. Then, Ms. Nestor, what
I can't wait to see all these texts in.
What is defendant's request with respect to lines 16 through 20?
Your Honor, all we're asking is at Lisa Darden's statement, which starts at line 16. And then the next question is, when Eric ate the sandwich, he immediately broke out in hives, had trouble breathing. He later told his friend he thought Kouri tried to poison him. We're asking to redact that whole comment of Ms. Darden.
Mr. Lauber, the statement.
Your Honor, I think just as some context here, Lisa Darden is reading from, I think, it's the interrogatories in the civil case. That's why she uses the word question. The important part from the state's perspective is Kouri Richins' response there, ridiculous, right? So the preceding paragraph is necessary for the effect on the hearer. I think the court can instruct around any hearing.
Wait, who's reading to her? Is it her mom?
Why she uses the word question. The context here, Lisa Darden is reading from, I think,
her mom. So her mom is reading to her from transcripts or depositions to her in jail. Great move there.
Yeah, it's the interrogatories in the civil case. That's why she uses the word question. The important part from the state's perspective is Kouri Richins' response there, ridiculous, right? So the preceding paragraph is necessary for the effect on the hearer. I think the court can instruct.
Of course, Kouri would think that. They're ridiculous. He's so obsessed. How long, Void? It was at the end of yesterday, day 10. I did add timestamps to yesterday's. I mean, yesterday's stream was one of the better ones in a while. I think it's my favorite since maybe the what's his name? The idiot, the moron that was. Got to look up his name.
Rocked around.
What's his name? It was a one-off video. Remember? No, I'll just keep.
Any hearing.
Right before the gay text was probably the funniest moment of the evening.
Say problem about considering it for the truth of the matter asserted.
Okay. Defendant's request to redact lines 16 through 20 of page 7 of 2.
Cyrus Warren, that's who I'm thinking of. Probably my favorite stream since Cyrus Warren. Not that there haven't been good streams in there, but I'm saying this one replaced that one.
2-76T is respectfully denied because that information that Eric ate a sandwich, that he broke out hives, had trouble breathing, later told his friend, non-specifically who that is, that he thought Kouri tried to poison him. All of that has already come in through other sources of evidence. That will not introduce any new information to the jury if they were to fail to follow the court's instruction that they cannot consider the non-Kouri Richins part of these conversations for their truth.
Your Honor, can I just also, while we're just making the record, we would also ask that lines 9 through 13 be redacted on the same grounds. I understand your ruling, but I just want to make it proper that we'd also want redacted. So they're saying they're saying just a few days later, Valentine's Day, Kouri made Eric a sandwich and placed it on the seat of his truck along with a supposed love note. I don't believe that has come in.
Dear God.
Yeah,
I don't know if it's come in, but I don't know why you would keep it out.
Respectfully disagree. I don't think it's ever come in. He had trouble breathing. And I just want to make a record.
These are things she said, right?
On that, but I understand your ruling.
Okay. Let's see. I think that handles 2-76T. Let's go to 2-77T. Defendant objects to redacting the following two sections. Line 20, page 21, lines 14 through 25. This just seems to be a self-serving statement by defendant that is not necessary to provide context for, or explain any of the other unredacted statements.
No, Your Honor, but the defense loves those the best.
Why is this necessary under Rule 107?
Page 21, lines 14 through 25. We don't need that. We'll withdraw that.
Okay. Thank you. And then, same exhibit, 2-77T. Please go to page 25, lines 2 through 16. I'm not sure why this is Rule 106 material either. It is almost entirely Ronald Darden's statements with just Ms. Richins non-substantively responsive.
Okay, I don't need anything above line 14. But line 14 is the beginning of her sentence that starts on line 7. Okay. So we need 14, 15. I don't really care about 16. It doesn't. I think he's talking over her. But 14 and 15 is the beginning of the
is he mansplaining?
Sentence that they start with 7.
And what's the problem with lines 17 through 19? This is Kouri Richins' statement.
She's saying her mother was telling her, so it's triple hearsay. It's her mom telling her what her mom read about what other people said.
Okay, and then doesn't she go on to talk about that on the following pages?
I'm not sure what you're asking me.
Gungan.
If we don't include lines 17, 18, and 19, we don't know what she's talking about when she says stuff.
Perfect. That's what the defense wants. That sounds great to the defense. We don't know what she's talking about. That is exact. That's no objection here, Your Honor.
Showing that I bought lunch at Mirror Lake, like I didn't make any fucking sense. It's context for what she's talking about.
I don't think any of it should come in. I mean, it's all talking about a triple hearsay statement, and she's addressing it.
It's her making comments about what did or didn't happen with respect to the sandwich on Valentine's Day.
That's
her relevant.
Responding to what the triple hearsay statement.
No, her response is saying something different.
And is saying
context in this economy?
Well, that's fine, but the statements made by other people do not commit for the truth. Her statements are admissible as categorically non-hearsay.
So you're going to make an instruction on this one as well?
I'm making an instruction on all that they can.
Defense, this isn't the judge's first trial. And if you follow along, that's what the entire day is about.
Not consider the statements that are made by people other than Ms. Richins for the truth of the matter asserted.
So, I'm sorry. I did not understand that you were suggesting that you're making one instruction for everything. I don't know how they're introducing these. I don't know if they're all...
Make an instruction every single time.
That's what I'm asking.
Yeah, happy to.
Okay.
Any other objections regarding...
Your Honor, we don't think any of it should come in.
Oh my God, please don't make an instruction every single time if they're being introduced one after the other.
And we think it's all hearsay. We object to all of it.
You
object to all of it.
Have to be more specific. Do you believe that Ms. Richins...
Now, I believe, and somebody correct me if I'm wrong, I wish Craig was here. I believe the reason it's important to say what you object to, because the defense wants to say we object to all of it, so then later on appeal, if they're able to get something overturned on one of these things, they raise the objection, right? Versus the judge is like, no, you got to be more specific on what you object and why.
Statements are hearsay.
Yes, because she is incorporating into her statements the hearsay statements that others are making about what happened in order to give her own explanation. So, yes.
Okay. Any other objections?
No, sir.
Defendant's objection is overruled. Ms. Richins responding to questions posed to her by other hearsay speakers is categorically not hearsay. The court can instruct around the possibility that the jury might consider the statements of speakers who are not Ms. Richins accepting their statements for the truth of the matter.
You lose, Gungan. For those that didn't see Night 10 yet, here's a 1-minute clip. This is when Sue and I were both dying. Just to relate to what it is, and we'll start the video again here. Just to pump some life back into this content here. We are talking about a text message exchange that Sue and I had a month or two before. We couldn't remember why I had said something, but then I went back and found it, and then I relayed what the conversation was about. I moved that to the beginning of this clip to give it context, like the defense hates, but here we go. We were talking about the fat activist who got arrested at the hospital. Remember that the woman who was like 800 pounds, like,
yes.
And she's like, rape.
Yeah, they have to I don't know. She was just on a tarmac for 3 hours.
I said, if I ever start making quote body positive end quote content, mail me a hand grenade with the pin without the pin. Yeah, you see, but just in time, I'm replaying the little text exchange clip. And then you followed it up with actual LOL. And then I said, if I ever start rating different rascal scooters, mail me some high quality anthrax. Oh, thank you for reminding me of that.
Yeah. Thank you for finding it.
Yes, that is my testimony on direct.
Okay. Now let's go to the one of the safe. Can you pull up the clip?
All right, going back. But yeah, check out night 10.
Mr. Bloodworth, anything further there?
No, Your Honor.
Okay. That handles 277T.
I mean,
All right, let's go to
the entire stream was almost like that. I was watching it. I was just finding clip after clip. That's why I'm trying to build up clips for end of year when I can, just doing screen recordings, and then I'll have to go through that. But yeah.
278T. Mr. Bloodworth, take a look at page 11 with me, please.
So, Your Honor, maybe I can head some of this
Please.
off. So this, along with, I think, 2-90, right? This all goes to recovery of the walk the dog letter, which is entangled with a whole lot of Kouri. I have a proposal.
Why is recovery of the walk the dog letter going to be an issue that comes in before the jury? I've already ruled on any motions to suppress it.
I don't think it has to.
I'm so sorry. Which number are we looking at right now?
Currently, we're looking at 78T
Youngin.
and 90D.
You don't even
So
know what
at the
page
outset,
we're
from the
on.
state's perspective, in introducing the walk the dog letter, how it was recovered.
This is like when we're in school and then, it's reading. Everyone's reading and then the teacher calls in like, oh, why don't you continue now? And then you haven't been following along. You're like, where were we at again?
I don't know that matters. But I can envision a scenario where, for example, the defendant has said that this 6-page walk the dog letter, it's been redacted down, but 6-page walk the dog letter was part of a 65-page fictional manuscript, and it was recovered from the middle or whatever of that manuscript, and the context of it, the context of the 6 pages is within the volume of a book. That is untrue, and we could prove that by proving how it was recovered.
Let's go in order of events, though. In terms of Jeff O'Driscoll testifying about the walk the dog letter. Go ahead.
Here's my proposal.
Please.
I would like to show Jeff O'Driscoll a copy. Is this an accurate depiction of a 6-page letter to Lisa Darden written on either September the 12th or 13th, 2023, that investigators recovered on September the 14th, 2023, from a book that was among Kouri Richins' personal possessions?
Any objection, Kevin?
Rather than bringing in, so the idea would be he's not going to bring in 278T and
No, ma'am, pay attention to what we just talked about.
We'll start there, and it will inform what we do with 78T and 90D.
So the way he just explained that answer, I don't know what I could object to.
Well, if you object,
but I want to.
at the foundation, you're going to create a process. I just need to have what he's proposing is that question be non-objectionable based on foundation by stipulation of the party.
Well, I don't plan to object to that question because I don't want to get into the fact that her cell was rousted.
Right.
Rousted? You mean searched? Can you believe it, people? The jail staff, they didn't even honor Kouri's privacy in jail.
So, I mean, I'm certainly not going to open that door.
Okay. So if it comes in.
I think you might. I still think you might. Because you do on all the other shit.
In that way, as I understand it, there's no need for the state to use 2-78T or 290D in its case in chief. Is that accurate?
Correct.
Okay. Ms. Nestor, anything further there?
No, sir.
Okay.
Exactly, Pizza 1907. That's what I keep saying over and over. These lawyers are bad. I think XD was asking me and Sue since we watched them record, like, how bad are they? And I was like, this is one of the worst I've ever seen. They are usually in a trial, you might get one like oopsie where you don't expect the answer the witness gave. They're doing it over and over, like every other question.
Okay, then can we go to?
Doesn't matter that there's cases weak. They are making it worse. Yes. Robin Yater, our potent, she knows. She's legally trained. also a lawyer, I believe, right? But
2-93T. I think this is Ms. Richins talking about speaking with Ms. Bramwell and Heber.
Just very briefly, Your Honor, I think they missed redacting the word jail call on the first page on this one. If we could just make sure they do that.
On page 2?
On page 1, cover page, up at in the heading.
Oh, I don't think we're showing any of the cover pages of any of these, right?
I think they have the dates on them, so they may.
Yeah, Your Honor, we did miss that. We will fix that.
My apologies. Okay, very good. So jail call 1 will be redacted from the caption on page 1. Thank you.
Yes, everyone better be wearing their Sunday best when listening to this. And I will require everyone to send me autographed pictures holding today's newspaper, showing me in your Sunday best while you're listening to the stream. And then maybe like in the background, you have the screen up so I know that's what you're doing.
Help me out. What is the probative value of this one, Mr. Bloodworth? And is this only one that might come in rebuttal, or is this the case in chief?
No, Your Honor, the state withdraws this one. Now that we've resolved the Bramwell issue and she's testified, this is no longer necessary.
Very good. 2-93T is, all right, 2-94T.
I think the only, Robin the ADR Pro qualifying, or adding to my prior statement, she's a trial lawyer, administrative law judge, arbitrator, paralegal instructor, among other experience. For some reason, I was thinking guardian ad litem, but I think you just explained guardian ad litem the first time when saying that you were what you're done. So yes, thank you. Everyone listen to what Robin the ADR Pro says. She's much smarter than me. But they are that bad.
Part of this is regarding the vacation booking statements. Part of this is Kouri Richins making.
Oh, yeah. And I'll back it up here because I stopped on this. I wonder how many cases they tried the defense in criminal court because they seem unfamiliar how to try a case, disorganized. I don't think they do much private practice, right? Because they also got the Charlie Kirk shooter. I think they just rely on being on the docket wheel. Who would hire these people?
Is this only one that might come in rebuttal, or is this the case in chief?
No, Your Honor, the state withdraws this one. Now that we've resolved the Bramwell issue and she's testified, this is no longer necessary.
Very good. 2-93T is, all right, 2-94T. Part of this is regarding the vacation booking statements. Part of this is Kouri Richins making statements regarding the vacation booking statements. And part of this is regarding the thing in Heber. Candidly, the statements or the back and forth regarding the quote-unquote thing in Heber is pretty confusing. The first part, I think, is more clear probative.
Fair enough, Robin.
This one also, Your Honor, they missed jail call cover page. If we could just redact that.
Robin, I don't know if I got your answer on this. Robin, do you think she's going to testify? I absolutely want her to testify. I think she has to testify based on the case so far, or else I really don't know what their strategy is going to be. What? Oh, yeah, Suma says, trust me, you are much smarter than him. I am incredibly stupid. Me no brain have. But Robin, do you think she's going to testify?
Scott, page 1 of 2.
Thank you. See? And I already crowned Robin the ADR Pro as the expert and much smarter than me before I heard her answer. And she agrees with me, everyone. So, yeah.
94T in the...
This one also, Your Honor, they missed jail call cover page. If we could just redact that.
Scott, page 1 of 2-94T in the caption. Please redact jail call 2 from the caption.
Your Honor, because of the way the evidence draw this one as well, I can envision some corner cases where we might want to revisit it, but for now, let's just...
Very good. And then the video, 2-110, we don't need to offer that, right, Mr. Blair?
Oh, no, sir, that went the same way as...
Okay. Ms. Nestor, I think that resolved the state's docket 1165. Anything further on that?
No, sir.
Mr. Blood?
No, sir, nothing on that. We recently identified 3 additional jail calls that we've redacted. We'll send those to the defense. I don't anticipate.
Okay.
So they're sending more calls to the defense. That's not going to work. The defense is already overloaded. They haven't done their homework all semester.
So we may have additional similar discussions.
Understood. And then, may I ask about the state's motion to admit redacted exhibits 8-57R3, 8-63. That is the state's designation of prior consistent statements by Carmen Lauber. Maybe talk mechanics for just.
All right. So we're getting to the Carmen Lauber part. Shit, I forgot to write the timestamp for the walk the dog. Libby says, I think her attorneys will convince her it's a bad idea. Now, you could read that two ways. First, they're terrible attorneys. So, you know, who's to say that they would be able to convince her? Second, I don't think she would listen to her attorneys. What? She knows better than anyone. She already lost an attorney, remember? She called her a dumb bitch, and then they got off the case for another reason. She's lying to her attorney. She thinks she is the smartest person on her defense team. That's why all this bad info is going to her lawyers, because she keeps lying to them. Oh, Miss Cricket, you're getting Mormon questions. Or questions about Mormonism. I guess my question for Miss Cricket would be like, how much, well, I don't know, this might be, since you are Mormon, it might be hard to like see it from the outside, but I was wondering like how much of what Kouri did, not the murder, right? But like how much of how she acts in public, right? Like her hair, right? Is she trying to do this just as like looking conservative, or is this like a direct attempt to appear extra Mormon for what are potentially a jury full of Mormons? I don't know if my question made any sense there, but maybe.
Just a moment.
Yes, sir.
How are these coming?
So, Your Honor, in questioning,
I guess this is the question. How much of what Kouri is presenting herself in trial as is meant to hint, I'm a good Mormon woman, versus hint, I'm innocent? I guess they would tie it together, right? But do you see anything like that? Right, exactly, Robin the ADR Pro. Kouri will testify because she knows she is smarter than everyone and can talk her way out of the conviction. Exactly.
Recognition of prior consistent statements by Carmen Lauber. Maybe talk mechanics for just a moment.
yes, sir.
How are these coming?
So, Your Honor, in questioning, Jeff will ask him about conduct, the interview. Carmen Lauber, ask him about the defense. He was present when the defense questioned Carmen Lauber about certain statements. In context, do those, are there? No.
So I appreciate that the state has evidence through Jeff O'Driscoll and perhaps that the arc of the interview, particular conduct by law enforcement officers or investigators, and Ms. Lauber's responses thereto are not the same as suggested by defense's cross of Ms. Lauber.
Right.
But you can elicit that evidence through Detective O'Driscoll's testimony.
There we go. Compass Realty Hitman, always coming in and saving my butt. The question I'm asking is Kouri doing things to appeal to Mormon culture? She has a reputation to uphold, and she wants to appear like a sweet, innocent woman. Right, but Miss Cricket, this is what I'm saying. Like, to me, looking at Kouri, she looks odd. Like, the haircut is odd to me. The choice in outfits, I know she doesn't have a super choice because it's all jail, but it's odd to me, like what her choices are.
And to the extent you need to show that Carmen Lauber testified consistently with her direct versus the suggestions of what she said or what she said on cross, you can certainly do that. My question is, though, it seems like a lot of this is being shown the arc of the investigator's conduct rather than just Carmen Lauber's prior consistent statements. Now, I understand context matters, but do we really need all of it, is my question.
Your Honor, the state tried.
Okay. I keep talking over this because we keep it on this side debate, but Rocky says her hair and style is the same as before. No, it's not. Look at her when she's on TV. Look at her in the photos. She's got her hair loose. It's hanging down. She doesn't have it all pulled tight on TV. Lori Daybell had all the crazy long curly hair. Lori Daybell talked in a certain way, but she dressed, I would consider the way she dressed to be average.
By defense's cross of Ms. Lauber.
Right.
But you can elicit that evidence through Detective O'Driscoll's testimony.
I guess I'm going to give an explanation here. So we're talking about Carmen Lauber's testimony. If all of you remember, at the end of the cross of Carmen, the state wanted to admit all of the transcripts of her interviews with police, showing that there's a clear arc of how her memory was reconstructed by digital devices, digital records. They were not feeding her the story. And she was being truthful. She was just remembering more as it went along, but it's, the entirety of it, it was like 1,000 pages. The defense objected, saying, well, there's so much hearsay in there, we can't do it. Now, again, the judge said, well, some of it may come in, but prosecution, you have to pick out what you want to introduce to rebuff the defense's assertion that she's changed her story, put it in a motion, submit it. They did that 2 days ago. Said, okay, these are the sections that we want from these transcripts in a motion. The defense has had that for a couple days. And remember, the defense was against any of it coming in. Now they're going to argue that they haven't had time to look and they need to look at all the transcripts again. And they'll even go back for, well, we should just do it all then. This shows that they are not keeping up with what they should be.
And to the extent.
And they're a team. I don't understand what they're all doing. It's not like they all have to be doing the same thing at once, but it seems like that's what they're doing. All of them are working on the same thing at once. Why not have Ramos work on this? Ramos, we haven't heard him for a couple days.
You need to show that Carmen Lauber testified consistently with her direct versus the suggestions of what she said or what she said on cross. You can certainly do that. My question is, though, it seems like a lot of this is being shown the arc of the investigator's conduct rather than just Carmen Lauber's prior consistent statements.
And that's what the state wants to get in, right? So there's a little problem. You got to overcome that.
Now, I understand context map, but do we really need all of it, is my question.
Your Honor, the state tried to narrowly tailor the amount of information. I think...
And to be clear, I recognize that we went from 900 pages down to 100.
I think those...
It went from 900 down to 100. So they've eliminated 90% of it. That seems pretty good.
100 or so pages, narrowly tailored, are kind of the minimal amount to show the mode Carmen Lauber's, that it was more, certainly there was a self-serving piece, but there was a lot more than a self-serving piece, and that she was not motivated by Detectives O'Driscoll and Maynard bullying her. I think the full expanded 900 pages show that the best. I think the 100 or so we culled to show it enough.
Do you have these as one kind of video clip that plays from interview to interview, or will you provide some signposts for the jury?
Your Honor, we don't intend to publish them. We intend to make a few points from them through Detective O'Driscoll's testimony, provide them to the jury, and in argument argue something like, you heard the defense cross-exam of Carmen Lauber. You heard Detective O'Driscoll's testimony regarding those interviews. You have them before you if you want to, or you have these excerpts before you if you want to dig through them and determine for yourself what the evidence proves.
Okay.
And remember, Carmen's still under subpoena. So the other problem for the defense arguing this is the defense can call her. They kept her under subpoena, or I think the state maybe did too, because they had to work through this transcripting. But the defense caused this by saying that that Carmen changed her testimony and she was coached, essentially. The defense caused this problem. Not that they can't undermine the credibility of a witness, but the way they did it, I'm not a mind reader, but I'm Rob Nieder Pro. What did Forever Wonder say? I'll have to read back.
I appreciate the I have a genuine question as to whether I can send these transcripts back into when I'm not sending other transcripts of other testimony back into the jury.
Your Honor, it's not testimony. It's evidence. It's an interview.
I mean, we'd have to go through the Crawford out of Ms. Lauber's statements were testimonial. Now, there's not a Crawford problem because she was on the stand.
Correct.
But whether these qualify as testimony with respect to the concern that providing transcripts of certain testimony would give that certain testimony undue weight.
I'm guessing, well, they keep saying Crawford. I don't know what Crawford is, but I would imagine based on context that the Crawford problem, it's referring, I assume it's a case where you need to be able to cross-examine somebody on what they said. And they don't have the problem because she was up on the stand. The defense could have asked anything they wanted. And she's still under subpoena. They can call her again as well. Forever Wanderer said, Robin the Eater Pro, to me, this felt like they're being difficult for difficulty's sake. Are they just dumb or conniving? And Robin replied, I'm not a mind reader. I am finding it hard to... I'm not a mind reader, and I am finding it hard to believe the defense team is actually that stupid. They may have a plan, no matter how ridiculous it seems to us. I'm going back. I never... Hanlon's razor or whatever it is. Never assigned to malice what can be easily assigned to stupidity. I'm just going to call it the Visser rule. Shit. Gotta edit that out. Ah, damn it.
When transcripts of other testimony are not provided, I have a genuine question about. So I'm not suggesting that you can't.
Now, Occam's razor is whatever, the simplest explanation is always the easiest, right?
Publish.
Sure.
No, I'm not talking to Occam's razor. Never assigned to malice what can easily just as easily be attributed to stupidity. So, under that rule, the defense team is just stupid. And we have all the evidence that they are. They keep stepping on rakes. They're also scheming, but they're scheming in stupidity.
I'm asking whether you have to publish, but she was in custody. She was being
Hanlon's razor. Thank you.
Questioned by law enforcement officers. I think there's at least a reasonable question as to whether this would qualify as testimonial in quote unquote.
I think two things, Your Honor. In some measure, that's why the state moved to admit the entire shebang. But I appreciate the need for efficiency.
Right.
The second thought I have is to the extent that the defense wants to further cross-examine Carmen Lauber on these, or Detective O'Driscoll or Detective Maynard, they're here. We can all recall them easily.
I agree.
Yeah, look at this. This is the face that I have all the time looking at them when I'm listening. Bloodsworth's face here.
Yeah, no, I agree with all of that. It really comes back to the issue of whether these transcripts go into publishing. You're right.
Yeah, and okay, and this is the main argument. Do the transcripts of the interviews go back with the jury? Does the video of the interview go back with the jury? How much do we introduce in front of the jury, etc.? That's all they're arguing over here.
You have the right to publish them to the extent you. I am not persuaded. So we don't have to necessarily reach agreement on that now, but how do you want to address on recognizing that they may not?
Your Honor, that would alter state's direct of Detective O'Driscoll because we would end up publishing 100 pages.
You have them as video or audio, though, too.
Well, right now, we only have the transcript. We were waiting. Video editing is long and expensive.
I see.
And so we were waiting.
Hey. Video editing is long and expensive. Sir, I edit this trial every day. Now, I'm not counting this as a good work right here because I'm just doing it quick to cut out pauses. It ain't that hard. Tell me where you need it. If you gave me the sections of the transcript that you wanted in a video, I could do it in about 2 hours. I'd do it for free, sir.
To nail down the transcript to then conform the video.
Is audio easier? Do you have audio files?
What did
Mr. Rack is saying no.
It's the video file's the audio file.
I see. Okay.
It's one.
I see.
Video files, the audio file. Carolina Hunter Tato says they aren't dumb hearing out. That's them being strategic. They won't be ready tomorrow morning either. No, two things can be true at the same time. They can be stupid and conniving in terms of wanting a delay, but what I'm saying is they are mostly stupid. because of the questions they're asking. They are trying all the TV lawyer tricks that just blow up in their face.
So there's no distinction in terms of editing time between a video and an audio file.
All right, pause there for a moment. Maybe I may be taking on more than I need to. Ms. Lewis, what's the...
Your Honor, I mean, we object to these coming in this way. I think that
when you say this way, what do you...
by publishing any of these transcripts, I think you're correct that the appropriate way to do this would be through direct examination of Detective O'Driscoll. They can certainly ask him questions to try and rehabilitate what Carmen Lauber said.
Can ask him questions about...
Thank you, Rob the Pro. Crawford is a confrontation clause, and that is not a problem when the person has appeared as a witness because they had the chance to cross-examine him versus like the victim, right? You can't cross-examine the victim about what he said for hearsay. I backed it up because I stepped on it. I have such a good chat. They're all so smart. You're all so smart. Congratulate yourselves. Everyone, give a standing ovation to yourself.
Maybe I may be taking on more than I need to. Ms. Lewis, what's the...
Your Honor, I mean, we object to these coming in
Remember to hit the like button, please. And subscribe if you're not.
this way. I think that
when you say this way, what do you...
by publishing any of these transcripts, I think you're correct that the appropriate way to do this would be through direct examination of Detective O'Driscoll. They can certainly ask him questions to try and rehabilitate what Carmen Lauber said.
Can ask him questions about what he said. They can't ask him questions about what she said. That'd be hearsay.
I understand, but the problem that as they see it, if I understand it, is they're trying to put forth that she wasn't influenced by law enforcement. So they can ask questions of Detective O'Driscoll about that. But putting these in, I do believe is a Crawford problem.
Well, we got to be, I need you to compartmentalize the objections here. These are being offered as prior consistent statements of Carmen Lauber to rebut a charge of either recent fabrication or...
I understand.
So any objection under that...
Yes, that should have come in under Carmen. During cross-examination, it's fully within our right to pick out portions of this interview.
You can recall her, right?
I don't think that's our job to recall the state's star witness. They had her on the stand.
I just asked you a yes or no question. Would you start there for?
Would we recall her? Yes, that is something that could be possibly done. I don't imagine what world the defense would do that.
And correct me if I'm wrong, you had the transcripts when you cross-examined her, right?
Yes, but so did they. And the appropriate way to do it would have been to try and rehabilitate her on redirect, which would have then given me a chance to go into other statements.
They sought to,
cross.
And
I was distracted by the chat, but I really don't like Zelda here. I'm going to back it up to where she started again. Sorry, one more time. It's the last time I'm backing it up on her, but I'm really going to focus on this here. Stop being distracted by chat.
Say this way. What do you...
By publishing any of these transcripts. I think you're correct that the appropriate way to do this would be through direct examination of Detective O'Driscoll. They can certainly ask him questions to try and rehabilitate what Carmen Lauber said.
Can ask him questions.
Said.
About what he said. They can't ask him questions about what she said. That'd be hearsay.
I understand, but the problem that as they see it, if I understand it, is they're trying to put forth that she wasn't influenced by law enforcement. So they can ask questions of Detective O'Driscoll about that. But putting these in, I do believe is a Crawford problem.
Well,
how in God's name could it possibly be a Crawford problem? Based on Robin's explanation of confrontation. If there's two people having a conversation and both of them understand, what is the problem with confrontation?
we got to be, I need you to compartmentalize the objections here. These are being offered as prior consistent statements of Carmen Lauber to rebut a charge of either recent fabrication or...
Understand.
So any objection under that?
Yes, that should have come in under Carmen. During cross-examination,
I did not see that, Sumo.
It's fully within our right to pick out portions of this interview.
You can recall her, right?
I don't think that's our job to recall the state's star witness. They have.
Zelda. First, not really the star witness. I would argue it's not the star witness, in my opinion. I would say the PI was the star witness. I guess, you know, whether you're relating to the case or whatever, I would say Kouri has supplied most of the evidence of her guilt that is being brought in. Kouri is the state star witness. Idiots. Robin the idiot. And you can call her up if you want. Remember, you started all this on your cross-examination of Carmen saying, oh, you're lying. You said all this stuff before, which you came off as totally truthful. Then you, what's the word? Not pampered, kid gloved the drug dealer who was shown to 100% lie based on the video of his interview. This is a temper tantrum, in my opinion. Do you see it that way, Rob the Idiot Pro? This is a lawyer having a temper tantrum. Yeah, Rob. Okay. Isn't it amazing, Zelda, that you cannot require the prosecution to... I think you missed a word in here, but you cannot force them to prosecute the case the way you want them to. It is amazing. I don't think Zelda understands that. And I think this goes back to their whole problem with questioning, right? I think in their heads, they convince themselves so much that something is going to go one way that when they ask the question, they are thinking that's only going to be this question, this answer. And when they don't get that answer, they keep digging and going back at the well for more rakes to the face because they're idiots. They don't... Yeah, this,
under that.
Yes, that should have come in under Carmen during cross-examination.
And I don't know how they thought the prosecution was going to do this case any other way. They have had all of this before the trial. None of this is 11th hour surprises.
Examination. It's fully within our right to pick out portions of this interview.
You can recall her, right?
Yeah, you can recall her. You can recall her and do whatever the hell you want. It's not burden shifting. It's called presenting your case, ma'am.
I don't think that's our job to recall the state's star witness. They have.
You don't have to recall her. You don't have to recall her. The state can do what they want to rebut your cross and then just leave it at that. But if you want to fix your problem, you're going to have to recall her.
Her on the stand.
I just asked you a yes or no question. Would you start there for?
Would we recall?
Can you answer the yes or no question first, ma'am?
Yes, that is something that could be possibly done. I don't.
You don't imagine a scenario where you would do that?
Imagine what world the defense would do that. But.
In a world where you want to try and convince people that Carmen is lying. You tried the first time and it failed, so obviously I would say we shouldn't bring her up again. But the world you can't imagine is the world we are discussing now, ma'am. That is the world we are discussing. Oh, Rob the Air Pro says, I will go back to the other question. I think these lawyers are just that stupid. Yeah, they're bad at this.
Correct me if I'm wrong. You had the transcripts when you cross-examined her, right?
Yes, but so did they. And the appropriate way to do it would have been to try and rehabilitate her on redirect, which would have then given me a chance to go into other statements.
They sought to.
Cross.
They sought to. Remember, ma'am? They tried to introduce it and you objected. You said, we haven't read this. It's full of hearsay. And then he asked them to write a motion, which he gave to you 2 days ago. These are not surprises.
Limited their ability to put in the whole 900 pages.
That's not how you rehabilitate. You rehabilitate by asking questions.
Right. Which they're going to do from the other person in the interview.
It's not by putting in an entire transcript.
Oh, my God. Yeah, I'm starting to yell. It's...
Transcript.
Well, you can do it, for example, by admitting prior consistent statements. And so I just need you to stay focused on that rule for a moment. I know I'm interrupting you. I don't understand how you think they were supposed to admit prior consistent
For
statements.
testimony.
That's not a prior consistent statement.
God damn, Zelda. Zelda! Is the judge your law school professor? Why does he have to keep explaining this to you? Rob Neater Pro says, These lawyers are not listening to anything and totally unable to process anything that isn't in their own imaginary script. Exactly. That's how I see this all the time. Like, they cannot conceive that everything their client is telling them is bullshit.
For example, by admitting prior consistent statements.
And not listening to anything. It's just like Lauren. When somebody's talking, you see this during the objections, right? When the judge is talking, they're talking to each other. They're just waiting for him to stop so they can argue back again. Blah, 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 blah. Hello, Michelle. I don't know, Robin the Editor. That's what I'm saying. I am not a trained lawyer, and I understand this. How did they not? It's not like they're not able to come up with an argument to overcome something that the state is introducing, right? They just don't agree or understand basic common sense. Hello, Carmen.
I just need you to stay focused on that rule for a moment. I know I'm interrupting you. I don't understand how you think they were supposed to admit prior consistent
For
statements.
testimony.
That's not a prior consistent statement.
I mean, this is so stupid. I keep backing up, but listen, the argument is from the judge. The prosecution is trying to put in these prior consistent statements from the interview to show that she is not lying on the stand now. How are they supposed to do that? The defense's answer is through testimony. That's not a prior consistent statement because it's happening right now on the stand. You idiots. That's what I'm talking about. These lawyers are stupid. This is not nuanced legal argument. This is a lack of functional logic in their brains.
The whole reason we have the prior consistent statement rule is because the testimony goes in a different direction, or there's a charge of recent fabrication or undue influence. And then you have the prior statement come in as substantive evidence.
Only while she's on the stand. They didn't even attempt to question her about whether or not to pull out these portions to show, oh, look at, you weren't unduly influenced. Look at, you said this. Is that correct? Is that correct?
Yes, they did. They tried to admit the whole damn thing.
That's how you would normally see this done. Then I could have cross-examined her. And I also want to point out that they have taken very small portions of this that leave out the portions of the interview where she is being influenced by.
Oh my God. Not the one I want. Literally, Zelda. Why are you explaining it to us how it works? Since you clearly don't. You're just explaining what can still happen, what could have happened, what they did, and you're just saying, well,
statements of law enforcement. This makes it look like, they've cherry-picked what they want. And for example.
Well, no shit. Zelda, they picked out the stuff to combat what you tried to get the jury to believe, that she was lying and changing her story in order to get favorable attention from the prosecution in the state. Now they are picking out statements since you didn't want it all in, and it couldn't be let in because it was hearsay. Can't be all in because you would be proving the truth of the matter, technically, is what the judge ruled. So they went back and grabbed the statements. Now, once they do that, Zelda, you can go back and be like, oh, well, yeah, well, what about this? The problem is, I really don't think Zelda and her team have read the full transcript. That would make the most sense, that they didn't read it all. They probably plugged it into a search and, search for change, or they had one of their temps do it.
I want to pull out the May 10th interview. I don't even understand why this would be coming in. All they've pulled out is a conversation between Ms. Whistler and Ms. Lauber that Ms. Lauber is supposed to testify before the grand jury. That's going to open up a whole door of speculation and what happened. I don't see how that has anything to do with what we're even talking about. And as I go through the transcripts, it's very much just what the state wants.
Could be AI. I would like to give them more credit. Rob the Editor, the trial plan was created by AI. Okay, maybe. It's 1,000 pages, Your Honor. We can't read it all. They read the Cliff Notes. No, that's what I'm saying. They just read some of it.
the jury to hear. I mean, if we're going to do this, which I think is completely inappropriate, this is a Crawford problem. This should have been brought in through testimony when Carmen Lauber was on the stand, so she could have been cross-examined.
They attempted to, ma'am.
They can bring in what they want through Detective O'Driscoll because we still have an opportunity to cross-examine him. But to just send back portions of a transcript that we've not been allowed to cross-examine on that point out to the jury just what they want the jury to hear is inappropriate.
And I apologize, you're jumping around a little bit. So put
a lot of it, not a little bit, a lot of it
aside. Sending transcripts back, I have concerns about that. Do you have any law for the proposition that prior consistent statements can only come through the witness?
No, shit. Now you're asking for law references, Your Honor?
That makes the statement.
And I apologize for my lack of bleeping out some of the cuss words I'm doing. I'm trying to definitely bleep out the F-bombs, but...
I would point to a case. Look up again. I had it. Just give me 1 moment, please.
Yep.
It's 366 P3rd 867, State of Utah, in the interest of JC.
I'm sorry. Would you give me the site one more time?
366 P3rd 867, and I direct the court to footnote 8.
Okay. All right. So I understand your objection there. Tell me why you think it's a Crawford problem. You had the opportunity to cross-examine Ms. Lauber. You did cross-examine Ms. Lauber. You used part of these interviews to cross-examine her, to challenge her on whether she just asked the law enforcement officers, investigators, just write her statement for her. I don't understand what a lack of confrontation Ms. Richins has had here.
Your Honor, let me help out the defense since they're not getting it. Your Honor, we liked it better when we had the cross and we laid all that doubt in our minds about the veracity of her statements. And, and the prosecution did a redirect, and then they helped, they asked her some questions if she was being truthful, but we like it much better leaving that impression with the jury rather than going back to the transcript and proving that it isn't as sketchy as we made it seem. That's what the defense is saying, Your Honor. I know I didn't cite any legal cases, but neither will the defense.
Because what is happening here is now they are basically crafting testimony on her behalf. They should have asked her these questions. I haven't had an opportunity to cross-examine her on what they now want to bring in. They should have brought it in through direct, and instead, which I get was difficult with her. She said she don't remember anything. Instead of doing the hard work to try.
Oh my God.
If you get the opportunity, you should kill yourself.
The state hasn't done the hard work?
These questions. I haven't had an opportunity to cross-examine her on what they now want to bring in. They should have brought it in through direct, and instead, which I get was difficult with her. She said she don't remember anything. Instead of doing the hard work to
What the little F are you talking about, Zelda?
Try and ask her questions. They just want to put it all in, and they want to cherry pick what they wanted her to say, which clearly would have been very difficult to get her to say. So the easy way is here. We're just going to hand you the transcripts that show you what we wanted Carmen Lauber to tell you, but instead, here, just read it without putting in the whole story or giving me a chance to go back and cross-examine her. And
Right. Well, can't you cross-examine the detective with the same statements?
I think requesting us to recall.
I know it's not as effective without Carmen, but you can recall Carmen.
Is burden shifting. That is not what our job.
I hate when lawyers say burden shifting. This seems. You know who else all the time said burden shifting? Somebody give me the answer. What case am I talking about? I talked about it on here. I did a live stream on it. I'll give you 5 seconds to guess. But one lawyer really annoyed me, kept saying, this is burden shifting to the defense. This is burden shifting to the defense. As they were making the most asinine arguments with a much more difficult case. Okay, nobody guessed it. Pro Burgers. Oh. This is burden shifting. That defense team, I hated her. I hated how she just could not stick to, I mean, she's treating me like, you're pissing on my leg, ma'am. You're pissing on my leg that the DNA of there wasn't a trial. He pled guilty, but I'm saying the hearings with the defense. Heck, just maybe check out the one Brian Kohlberger stream I did, and you'll get an exact idea of what the problem with that case was. The defense kept saying, well, it's evasion right of privacy that, the murder weapon DNA was plugged into a DNA search, came up with people related to the murder, and that murder happened to be Brian. You didn't invade. There was no invasion of privacy of Brian's rights. They were searching other people's DNA. And if you're going to claim the DNA on the knife was an invasion of privacy, then you're claiming it was your client that left the DNA on the knife at the scene. Dude, that was super frustrating. But I didn't think she was an idiot. These two are idiots.
That's not what we needed to do. They needed to take care of their witness when their witness was on the stand.
Look at her face. Look at her face when she says this.
Oh.
No, I said pro burger, like the idiots out there. Yeah, I was saying Brian Coburn back. I didn't say Coburn today.
Story or giving me a chance to go back and cross-examine her. And I think requesting us to recall her is burden shifting. That is not what our job is. That's not what we needed to do. They needed to take care of their witness when their witness was on the stand.
Look at that. I got the look at pause game is on point. Look at that face. Instead of a horror movie. Sumo Loudmouth says, you can curse a lot, and a lot of very big successful channels do. It just might limit the amount of advertisers, but not much. Michelle DeMattis and Margarita and some viewers, but See, I'm confused by that because I will get comments. I will simultaneously curse on this channel, and I will get comments about how many ads are being spammed by YouTube in here. And for the record, as I explained to most people, you could do one of two things. You can turn monetization off, or you could turn it on. Now, YouTube will take it away if you use a song for longer than 5 seconds, or a scene, a still image from a TV show that somebody wants to claim, right? But YouTube is still going to show ads. So if you're going to show ads on my stuff, give me some of the pennies, right? And I think I worked it out. It's about 3 cents for every, I want to say it's about, 3 cents for every hour of viewing by somebody. Maybe 30. I'm always getting that damn decimal point wrong. Yeah, they showed ads either way. But I will curse, and then I will simultaneously get complaints about how many ads there are when I'm trying to set it as low as possible. I turn it on, I say lowest as possible, and they will stick ads in every few minutes. I have to go in there and delete 2/3 of them. I can't imagine what high is. You would be seeing an ad every 10 seconds. Bethany K says, I finally got YouTube Premium just so I can watch Hear Me Out. Well, you're saying the other channels don't have the same problem? I mean, maybe channels that are sponsored don't do it. I don't have you always put it on low, but Suma, go in and look at the ad spots they put in there. Once you can look at it, they put it in, like the first ad is like a minute and a half before the intro's even done. And my understanding is that there's supposed to be ad slots, not an ad every time, like where they can maybe put something. That's how they present it. So, okay, well, here's a break here, here's a break here, here's a break here. And then, it would be better, it would be preferable to me if I could limit the number of ads. So let's say I say 10 ads. Well, okay, in a 4-hour stream, you're going to get an ad every 40 minutes. That sounds all right to me. But you're making me put in ad slots automatically, and then you're sticking ads everywhere while I'm cursing. Right. Has everyone had enough of this freeze frame troll yet? Got to pay the troll toll. Got to pay the troll toll if you want to get into that boy's soul. If you want to get into that boy's hole. Wait, it sounds like you're saying boy's hole. It clearly says boy's soul. Yeah, that's what I'm saying. Boy's hole. Boy's soul. Boy's hole. Got to pay the troll toll. You want to get into that boy's hole? You got to pay that troll toll to get in. Got to pay the troll toll. Get in that little boy's hole. Okay, Bethany K. Cool. What we're quoting now, for those who don't know, we're quoting It's Always Sunny in Philadelphia. I'll find it. I'm giving you a Gungan laugh yet? I can give you one right here. Hold on a sec. Which I have to do now because Gungan is no longer talking.
Remind me, you objected to the addition of any part of the transcript at the time they offered it, correct?
For the same reason. They offered it after she was off the stand.
Had they offered it the 900 pages when she was on the stand, you would have said okay.
No, I would have said.
No, I wouldn't have done that.
But you need to cross-examine her, redirect her and rehabilitate her testimony.
And so how do you see the rule regarding prior consistent statements working?
They need to get it through her. They could have put on prior consistent statements through her.
I really don't understand. You're saying that prior consistent statements never come in and you only can ask questions? Please.
I don't understand. I'm sorry, Your Honor. I really am not following what you're trying to say. I have never seen this done any other way than through a witness. That's why we have witnesses. If not, why have any witnesses? Let's just hand the jury all the evidence.
Do you notice how Ramos comes over right behind her and sits behind her? It's almost like he's panicking because he isn't. To be clear, Ramos's only problem was his behavior and his personality on day one when he, like I told Sue and them, he was acting like this was a huge landmark civil rights case, and he was cross-examining a member of the KKK when it was just the patrolman that was on scene. And he adjusted himself. So it's interesting to me that Ramos comes running over, sits behind her, almost like he's going to say something in her ear like, you sound like a idiot right now, or maybe giving her some solid legal advice. But I do believe her when she says, I don't know it. I'm totally lost. I don't understand this. That's the first true thing she said. We're going to hear it again.
Stand.
Had they offered it the 900 pages when she was on the stand, you would have said okay.
No, I would have said you need to cross-examine her, redirect her and rehabilitate her testimony.
And so how do you see the rule regarding prior consistent statements working?
They need to get it through her. They could have put on prior consistent statements through her.
I really don't understand. You're saying that prior consistent statements never come in and you only can ask questions? Please.
I don't understand. I'm sorry, Your Honor. I really am not following what you're trying to say. I have never seen this done.
Yeah, you're not following
any other way than through a witness. That's why we have witnesses. If not, why have any witnesses? Let's just hand the jury all the evidence. Let's hand them all the transcripts.
Okay, you're being a little hyperbolic now, Zelda. And I wouldn't say that you don't understand how this could happen. You've never seen this happen before, because this sounds pretty... Robin, help me out. This is not a crazy occurrence, right? This has happened in other trials. This is pretty boilerplate.
Well, no, be fair to how the rule works. Somebody testifies on cross-examination. Defendant makes a charge of recent fabrication, and then the proffering party.
Romero? Is it Romero? I thought it was Ramos.
Has an opportunity to offer prior.
Yeah, well, she's being 100% recalcitrant. Well, now I got to Google recalcitrant because I don't remember at this moment. Okay, people, new rule in the chat. No words longer than 5 letters. For the host's sake, thank you.
Through her.
I really don't understand. You're saying that prior consistent statements never come in and you only can ask questions? Please.
I don't understand. I'm sorry, Your Honor. I really am not following what you're trying to say. I have never seen this done any other way than through a witness. That's why we have...
Okay, I just Googled it. It fits. Recalcitrant is a person or thing that is stubbornly disobedient, defiant of authority, or difficult to manage. Yes, absolutely. That's a good word of the day.
Stand.
Had they offered it the 900 pages when she was on the stand, you would have said okay.
No, I would have said you need to cross-examine her, redirect her and rehabilitate her testimony.
And so how do you see the rule regarding prior consistent statements working?
They need to get it through her. They could have put on...
Jesus, I just saw HTC's thumbnail today. Assuming that thumbnail there, that's what I'm talking about with the spotlight, with the eyes. Ugh.
Prior consistent statements through her.
I really don't understand. You're saying that prior consistent statements never come in. You only can ask questions? Please help.
I don't understand. I'm sorry, Your Honor. I really am not following what you're trying to say. I have never seen this done any other way than through a witness. That's why we have witnesses. If not, why have any witnesses? Let's just hand the jury all the evidence. Let's hand them all the transcripts.
Well, no, be fair to how the rule works.
Yeah. This is why I called it temper tantrum.
Somebody testifies on cross-examination. Defendant makes a charge of recent fabrication, and then the proffering party has an opportunity to offer prior consistent statements to rebut the charge of recent fabrication. I hear you saying, no, they cannot offer the prior statements. They can only ask more questions.
They can offer them through the witness. They can say, is this your statement? And what if she says, I don't remember that? Okay, then they can refresh. What if she says, I don't remember that? Well, then it doesn't come in.
Okay, I think that's where maybe you and I differ on the way the rule works. Do you have any citation for law that says, unless the witness remembers, these don't come in?
Well, off the top of my head, I'd have to spend some time, but I would look at Rule 613 of the Utah Rules of Evidence that talks about, this talks about prior inconsistent statements, but applicants given an opportunity to explain or deny the statement, and adverse parties given the opportunity.
I didn't read a book. I just look at Google.
To examine the witness about it. We don't know what she would have said. We don't know if she would have said, she may have very well said, no, I didn't feel influenced at all. That's fine. They could have asked her that question. Then I could have cross-examined her or recrossed her to say, well, what about this? What about this? What about this? Now I'm denied any opportunity to do that.
Yeah, Margarita is correct. Michelle. My wife absolutely does not watch this show. I sometimes get my dad to tune in, and then my mom will watch over his shoulder, but my family does not watch this show. Not because they're busy or they don't like me. They just think this thing has zero, they think it's silly.
By just putting in statements.
I might as well be building popsicle stick bridges.
Don't know what else to say. I do think, as I look through the transcripts, they have only picked things that they want in that we don't know that Carmen Lauber would have agreed to. But had they wanted to put them in through her, at least then I could have questioned her. I could have questioned her. I could have said, so this didn't make you feel pressured, so that didn't make you feel pressured. So they said this, so that made it, so you felt you were telling, I don't know. You see where I'm getting. And I don't have any opportunity to do that in this way.
Thank you, everyone.
I think I wasn't saying that for questions. We can cross-examine Detective O'Driscoll, and the jury can make a determination of that. But by cherry-picking statements that they wanted Carmen Lauber to testify to, but didn't ask her, I think that's...
It's not the cherry-picking, it's the root, right?
It is.
You cherry-picked statements, too. Everybody cherry-picked statements.
And they could have done it on redirect.
Absolutely, Margarita, because for sure they ain't going to be in here. I making explosive... Well, no, what I thought I had was like, if I picked up a drug addiction, I would at least get sympathy at that point, probably.
It's not to.
Versus just, ugh.
Again, it's the root, not the cherry picking, right? If she were on the stand, the cherry picking would be a problem.
They could have, because then I could have gone back and pulled out other statements.
I think we're agreeing. Okay. All right. I take your argument seriously. Mr. Bloodworth, I'm going to have to take a look at this real quick. I understand this to be a threshold issue with respect to Detective O'Driscoll. Is that right?
Yes, Your Honor.
Okay. Anything further at the time?
Not on Paul. We have 5 minutes.
Of course, just so I'm clear, we'll take 5 minutes for you to confer with your team, and then you'll tell me whether this is a threshold issue that I need to decide before Detective O'Driscoll takes this.
Correct, Your Honor. It is.
All right. So the prosecution's going to take a 5-minute break, and in the 5-minute break, we're going to watch the troll toll. A part of it. I'm going to have to pause it because, I already got to edit this because I said my last name. So the live chat will possibly go away, but this will probably get cut out as well. So for those who are watching this in the future that don't see this clip in here because it's been cut out, it's Always Sunny in Philadelphia. This was a play that Charlie wrote about the night man cometh, and they they're doing it on stage at like a community theater.
On your lousy toll, troll.
The woman here is in the show Charlie's romantic, white whale. He's always trying to date this waitress, right? And she absolutely hates him. What makes it funnier is this is his real life spouse.
God damn it. Stop laughing at me.
Now, Mac is pissed because he's trying to be the villain and everyone is laughing at him.
You gotta pay the troll toll. If you want to get into that boy's hole, you gotta pay the troll toll to get in.
You got to pay the troll toll if you want to get into that boy's hole. You got to pay the troll toll to get in. Now, maybe if I move my picture over part of the picture, maybe that will prevent this from getting struck or whatever, but we'll see.
You want the baby boy's hole, you gotta pay the troll toll. You gotta pay the troll toll to get in. Troll toll.
Want the baby boy's soul. You gotta pay the troll toll.
What'd you say?
Troll toll.
Hey, hey, hey.
Troll toll.
Here's your troll, you confounding. Here's your toll, confounding troll.
Here's your toll, troll.
Oh.
Your boy away.
I remember now. What happens next?
At last, the boy's soul is mine.
The boy's soul, not his hole, because Mac is not gay. And just do some karate moves. Move my picture again. Maybe this will help. This is from It's Always Sunny in Philadelphia. Just search troll toll. Or Mac's gonna do his karate. And of course, the audience is laughing at him again. He's pissed. I love how the show makes it that they're only laughing at the moments that Mac is trying to be the most badass and serious. And this is the boy sleeping. And we'll hear a little exchange here between them. This is Dennis, an adult man.
Give me that leg, boy. No.
Dude, do you have
Get back. The light goes out. He says, dude, do you have a boner?
No.
Dude, do you have a boner right now?
Shut up, dude. Don't ruin this for me.
What? What the hell are you? Jesus. Okay, stop. That's enough, dude.
Does it hurt?
You have a boner right now? Don't ruin this for me. I only have the troll.
Boy's hole, you gotta pay the troll toll to want to get into that boy's hole. Gotta pay the troll toll. If you want to get into that boy's hole.
All right, back to the trial.
Now, that may change.
Okay, understood. We'll take a 5-minute recess. Thank you, Mr. Bloodworth. Before you weigh in, I need to fix a misstatement that I made while discussing Detective O'Driscoll's potential testimony. I made a comment in passing that he cannot relate Ms. Lauber's statements because they would be hearsay. That is overly broad. To the extent that the statement by Ms. Lauber that Jeff O'Driscoll would seek to relate while testifying qualifies as a prior inconsistent statement under 801D1A or a prior consistent statement under 801D1B, it is categorically not hearsay and he can relate. By the same token, it can come in through him. Ms. Lewis, I took a hard look at the case you cited me to, 366 P. 3rd, 867, footnote 8. There, the Utah Supreme Court related the competing positions by the state and the respondent. Those competing positions are substantively identical to the competing positions of the state and defendant here regarding how statements under 801D1 are.
All right, so I think what he's saying my non-lawyer brain. He's saying, I looked at this case, which mirrors what you two are kind of saying about this case here in the same way.
To come in, and the Utah Supreme Court expressly declined to reach the issue. They did not rule.
Oh, shit. So there's no precedent. Certainly hope that's not what the defense cited as legal precedent, because if there was no ruling, I think that's what he's just said. Let me back that up.
We have 5.
Potential testimony. I made a comment in passing that he cannot relate Ms. Lauber's statements because it would be hearsay. That is overly broad. To the extent that the statement by Ms. Lauber that Jeff O'Driscoll would seek to relate while testifying qualifies as a prior inconsistent statement under 801D1A or a prior consistent statement under 801D1B, it is categorically not hearsay, and he can relate. By the same token, it can come in through him. Ms. Lewis, I took a hard look at the case you cited me to, 366 P. 3rd, 867.
Yeah, Ms. Lewis. Okay, Ms. Lewis, if you're going to cite a case that attempts to go to the Utah Supreme Court for the very issue you're arguing as supporting you as in doing whatever you're trying to say can't be done, this is the... And then you find the judge goes, and they didn't hear it. They didn't even pick it up. What did you hope by that? Here's what I'm reading it as. She's sitting there doing a Google search. Is there ever, or she's on ChatGPT. Is there ever, turn this off a sec so I don't mess up my stream. Was there ever a stream where a trial where, they wanted to do triple hearsay and ruled on in Utah? And ChatGPT told her, oh, yeah, this case here. And so you just read it out without realizing they didn't even hear it. What if it had been heard and ruled in the way you didn't want it to go?
Footnote 8, there the Utah Supreme Court related the competing positions by the state and the respondent. Those competing positions are substantively identical to the competing positions of the state and defendant here regarding how statements under 801D1 are to come in. And the Utah Supreme Court expressly declined to reach the issue. They did not rule.
That's it. That's the Price is Right underwear. What the hell, ma'am? I got an email from Emily D. Baker saying the judge issued a new ruling after the court adjourned for the day, requesting more foundation regarding Carmen's statement. I don't have details, and I don't know what that means.
That they must come in through the declarant.
I kind of know what it means, but...
So, as I sit here today, there is no authority for the proposition.
You're emailing Emily D. Baker? You don't know a bestie relationship with Emily D. Baker, Robin the ADR Pro, and you're here? Yikes.
Position that prior inconsistent or prior consistent statements can only come in through the declarant witness as long as the declarant witness testified and was subject to cross-examination. Indeed, it is defendant's cross-examination of Ms. Lauber that creates the foundation for admission of prior inconsistent statements based upon Ms. Lauber having not remembered or having forgotten, though that's not what the state is seeking to do here, and prior consistent statements based upon an express or implied charge that Ms. Lauber was acting from a recent improper influence or motive, to wit, pressure applied by, among others, Detective O'Driscoll, the U.S. Attorney's Office, agencies like that. There is not a Crawford problem here. I also have another.
Oh, shit. Defense is like,
son of a bitch.
I thought regarding the transcripts going back, if you.
No, I'm saying I'm not saying anything about the rest of us, saying she's besties with Emily D. Baker. Oh, she has a short up explaining it. Okay.
I want to discuss that.
So maybe we can get the court's thought, and then I can incorporate that into.
I mean, and Baba Ganoush, I guess that's like a introspective question. What does that say about you?
State's position.
Sure. Under Wyatt v. State, 2021 UT 32, under paragraph 21, the Utah Supreme Court abrogated the common law rule that prevented testimonial transcripts from going back into the jury room based upon a concern of undue influence on the basis that Rule 17K of the Utah Rules of Criminal Procedure does not allow for any categorical exceptions to exhibits going back with the jury because the jury may take with them, quote, all exhibits, end quote, except those, quote, that should not, in the opinion of the court, be in the possession of the jury.
Robin the Idiot Pro, tell Emily D. Baker next time you're chatting with her texting to have me on. Can you imagine how that would go?
End quote. Now, typically that's guns, knives, poison, explosive. I still have some concern that given the volume of testimony that the jury hears, the only transcripts they would have in the jury room being this 100-ish pages of Carmen Lauber would attract some unwanted attention on appellate review. But under Wyatt v. State, 2021 UT 32, there's no categorical exclusion. Take it from there, Mr. Bloodworth.
Robin the Idiot Pro says, according to the EDB email, the defense responded to the judge that the Rule 801D1B is now moot. Can you explain what that means? Like, in simple terms, Robin, they're withdrawing their objection? No, Suma says it's moot. They're not cows, Suma. That's so disgraceful.
So, Your Honor, it's the state's position. Now I'm recapping a little bit of what you just said. It's the state's position that the court can admit the transcripts through Detective O'Driscoll. We don't need the declarant, Carmen Lauber. It's the state's position that there's no Crawford issue, in part because of the 801D1.
In other words, most of the morning was a waste of time? Okay, got it. Do they still need that 2-day continuance, though? Because they got to go through all 1,000 pages. I mean, they didn't get the 2-day continuance, but...
One required for opportunity to cross has been satisfied in this.
If I read what you're saying, Robin the Idiot Pro, in other words, most of the morning was a waste of time, and they said it was moot, means they realized they were idiots? Yeah, we know. Yeah. Kathy Nestor, a.k.a. Gungan, is representing the Charlie Kirk murder. And I have to believe that's going to be her and her besties in tow. Why would she not have Zelda with her?
It's the state's position that the defense, to the extent they want to recall Carmen Lauber, is not burden shifting. It's just that it's a defense strategic choice.
Joey on Friends said it was moo. But Robin, why would they do that? Here's the question, which I don't know. Why would you just, because it seems like you're conceding the argument, right? Why do that? Why not just go through and have the argument? Is it because they're just going to get spanked in court and they don't want to get embarrassed? Is that why?
And it's the state's position that the transcripts can go back to the jury. Now, having said all of that, prophylactically and out of an abundance of caution, the state is trying to, through her attorney, recall Carmen Lauber, put the transcripts in through her, and then publish 100 pages of transcript. As much as the state thinks that is horribly, horribly inefficient and unnecessary. We've reached out to her attorney. I do not yet have an answer.
Okay.
This is a threshold issue for, I don't know, the mid.
I don't like that. I don't like we can't find Carmen because remember, she couldn't talk to any of them about her testimony. The defense was a bunch of ass. to her. I really hope she didn't fall off the wagon due to the defense, because everyone loves Carmen.
Point of Jeff O'Driscoll's examination. So I propose our next witness is Chris Kochodimos to clean up some stuff from yesterday. I propose we next call him. We then begin the state's direct examination of Detective O'Driscoll. That'll probably take us till lunch. I may have a better answer at lunch as to how the state will proceed.
Okay. Let me just ask some mechanics questions. Why can't the state just ask Jeff O'Driscoll a bunch of questions about whether certain exchanges with Ms. Lauber occurred, and, to the extent he doesn't remember or can't remember specifically, use the transcripts to refresh his recollection and even show the jury, publish them at that time, but use him as the root? And if you want to call Ms. Lauber, you're entitled to do so.
Your Honor, that may be...
Yeah, and I'm no way saying that I know Carmen relapsed, but I don't like hearing that they haven't heard back from her attorney, because it sounds like maybe her attorney isn't able to get a hold of Carmen. And I can, that number one jumps to my mind as a fear. And it was already a fear of mine when they wouldn't release her, so she couldn't talk to anyone and know that she was not who the defense was portraying her as. Nobody thought that.
The route anyway, and it may just, from an efficiency standpoint,
exactly
going
what
through the questioning to ultimately get to refreshing and publishing, it seems to me that that's what's done. It will be more efficient to just publish the 100 pages.
Okay.
Because that's where we're going to land anyway.
All right. Ms. Lewis, please proceed.
I just want to make a record.
Go ahead.
Go ahead, Zelda. What the are you going to say that's going to make us hate you even less? Which we can't. Or no, sorry. Which could possibly make us hate you less.
We stand by our objection that allowing our consistent statements to come in without...
Yeah, well, they aren't that sophisticated. They aren't that intelligent to push her until she relapsed.
Out a sponsoring witness is a violation of both the Sixth Amendment right, of our client's Sixth Amendment right, and Crawford versus Washington. It also violates her right to due process under the
Oh my! I'm looking at this.
Right? State Constitution.
Does she have a cup with her own name on it? Is she so like she's got it turned towards the front? Yeah, I'm Lewis. Google me. Find me in the yellow pages.
In the federal Constitution, she is not receiving a fair trial. And the remedy that we should recall the state star witness absolutely is burden shifting, and we stand by our objection. If those 100 pages are going to be published, we want all of it published. We want all 1,000 pages.
All right. And
now they want all 1,000 pages. Remember when they objected earlier?
How do you want that to occur? Do you want to just play the interviews with Ms. Lauber?
Sure, we could do that. We could just play them all. They're 7.5 hours, but that
seems like you're being hyperbolic again, man.
So we want to do it.
And tell me why you want to do that.
Because there are numerous other portions of the interviews where she is being influenced by law enforcement and shows that she's willing to just go along with whatever they say, just as she stated. But I think to pick out, particularly, like I said, the May 10th interview, there are a lot of things she says in that interview that are inconsistent with all of her other statements, but the state just wants to publish that she was going to testify before the grand jury, which I don't even understand that. I mean, all that does is cause the jury to speculate and confuse issues. And that's just one example out of what they've pulled out of the transcripts.
Here's what I don't understand about Zelda's hair. Why would you go into a barber and ask them, hey, I want my hair cut exactly straight along the bottom because I want to look like a cartoon and I'm wearing a wig? Wouldn't they do that thing where they get the sideways sitters and be like, they kind of like make it look layered? Secondly, is she getting a bowl cut when she's going in there? Because why isn't there like a little bump where the hair, look at the hair on top from her part is coming all the way down? Shouldn't there be more hair underneath that would cause it to lift up? So is she getting a bowl haircut? She's shaving it underneath? I know I did a side tangent on that, but
we're back where we started, Mr. Bloodworth. This is the position the state originally took. Does this change anything?
What do I tell my barber? You mean teeth? Well, you may not have noticed, but I did announce that I had gotten a haircut on last Thursday. The first time I got a haircut in year and a half. And the time before that was 2 years. And the time before that was 2 years. I just said, hey, okay, well, I'll tell you exactly the language I used. I went in there and I said, hey, about a year and a half ago, I was putting my hair up in ponytails, and then I didn't realize that I couldn't just leave it like that indefinitely. And then I ended up with 2 Cocker Spaniel ears full of tangled hair, and then I had to try and untangle as much as I possibly could, but then I hadn't cut some of it. And when I finished, it ended up with a big V in the back of my haircut, and they tried to level it off. And now I would like you to make it even. So they cut off the extra 3 inches from the other thing. So if you look in other streams and I have like a long piece of hair here, that was from the parts of the V. So they did that. It was about a 3-minute haircut.
Your Honor, it's largely the state's initial position. The initial position of the state was then not to publish them, right? It was just to send them back so that the jury could, if they wanted to. I'm happy to send the whole things back.
Ms. Lewis, speak to that.
We're not asking, that's only if, we are not suggesting that that should happen, only if we're overruled. We'd rather it all go back.
Part, you can be a little bit specific.
We're not suggesting, it's not our position that any of this should go back. We're only saying if the court's going to allow some of it to go back, then under Rule 106, we need it all to go back.
Forgive me, you've pivoted again. It's stay away from going back. Let's just stay on pub. So
she's being recalcitrant. That's what I learned today.
I understand defendant's position to be if any of it's published, all of it has to be published.
Correct.
Okay. In response to that, the state, as I understand, is suggesting I'm inferring in the interest of efficiency, rather than publishing all of it, just make all of it available to the jury through the recordings and then allow counsel to make whatever arguments they want to make about, you should go back and listen to this part because you'll see this is what was. Speak to that for a minute. You could do that by stipulation.
I'm not going to stipulate to that. No.
So
our objection stands.
Let me start again. Imagine that your objection.
Look, judge is talking. She's making a side comment to Gungan. So disrespectful.
No.
So
our objection stands.
Let me start again. Imagine that your objection to
look at her.
Publishing anything is overruled. And that's the world you're living in. How do you want to proceed from that?
I mean, I think I said that. Then it should all go back. Or
again, you keep skipping to going back. I want you to talk about publishing for a minute.
It's showing up on the screen.
So my hesitation is just efficiency. Like I said, it's over 7.
It also doesn't help that there's a chair behind her, so when she leans back, it looks like she's sitting in that chair, and she looks like a midget.
Hours worth of video, but if that's how the court wants to do it, then yeah.
That's not what the court wants to do, ma'am.
No. That's what I'm asking you. So imagine, here, I'll just make a rule. I have considered carefully the authorities cited.
Not to sidetrack. Look at Gungan. What is she spinning on her middle finger? Is there a ring on her finger? What is she doing? She looks like she's daydreaming about eating the judge. And I'm not saying that because of her weight. She looks like a predator being like, yes.
By defendant and the state. I've looked at the text of Rule 801. Ruling as a matter of law that, one, there's no Crawford problem here because Ms. Lauber testified in open court under oath, was cross-examined in open court under oath. It is the cross-examination of her regarding the conduct and circumstances in her prior interviews with law enforcement and other agencies that creates the circumstances providing the foundation for admission of her prior consistent statements under 801D1B. So the defendants further, the court is not persuaded that the only witness through whom a prior consistent statement may be admitted is the declarant witness that made the statement. The court has not seen any authority for that proposition. So to the extent the defendant objects to any of Ms. Lauber's prior consistent statements coming in any way, that objection is overruled. So Ms.
Oh, defense loses again. She almost looks like, it reminds me of like when my cat is licking their lips like, I can't do it because the cats can open their unhinged, basically their skull somehow to get their tongue to go up.
Lewis, take it from this. Some of her prior consistent statements as designated by the state are admissible under Rule 801D1B. It's how we're going to provide that information to the jury that I need some input on.
Well, I guess
we could admit and send back into the jury room. Speak to those two.
Well, my understanding was that under the case you just cited, Wyatt, that you were going to allow the portions to go back to the jury room. Did I misunderstand that?
Well, I think there's a basis to do so. It gives me the willies, quite frankly, and that's why Mr. Bloodworth, out of an abundance of caution, is saying prophylactically to prevent any appellate issue there, we would just publish. But
yeah, see, Zelda, what you're not grasping here is the state is going to convict your client of murder. And the prosecution wants to make sure that isn't overturned on appeal. You, meanwhile, keep trying to make appellate issues, but you really are just damaging your defense. By throwing a tantrum.
The defendant believes, Judge, if you do this, the least prejudicial way for us to do it is to send the recordings, all 7.5 hours, into the jury room and allow counsel to make arguments about what they show and what the jury should take from. You could do that by stipulation.
Which is incredibly stupid, because if the prosecution is worried about there being an appellate issue on all, or, stuff going back to the jury room, too much information, and the defense is saying, yes, send it all, then that's not an appellate issue at that point, unless it's ineffective assistance of counsel, right? I think, Robin?
No, I don't want to do that. I think...
Oh, you don't want to do that after the judge explained how stupid it is?
That even though it's not efficient, the appropriate way is if any of the interviews are going to be published, they all need to be published.
Okay, only published.
Correct.
All right. I appreciate your position. Mr. Bloodworth, take it from there.
Your Honor, the state moves to just publish the narrowly tailored versions that we proposed as whatever it is, 8-57 through 63 are. I think beyond so, I don't think there's a 106 concern beyond that.
I don't know. We're going to find out, but okay.
Yeah, and as a compromise, the state is fine with sending full videos back, or some mix of publish the narrow pages and send a full video back. But the notion of publishing nearly 10 hours of interview I don't think it's productive. I think it's a waste of the jury's time.
And when the prosecution says it's 10 hours and the defense says 7.5 hours, I tend to believe the prosecution because the defense probably doesn't know how to add.
Okay.
We object to it all going back. It's the same problem.
You object to it all going back, but you want it all to be presented in court.
The problem arises is the same as, well, let me rephrase that. The jury's been told they're to rely on their memory of witnesses. If the whole thing goes back, they can go over and over and over her statements on the video, which is not what they can do with any other witness. So if it comes in, it needs to be published, and then they have to rely on their memory just like they would with any other testimony.
I appreciate that position. Why are we publishing all of it rather than just the parts or some parts of what the state has designated?
It's a great question, Judge. I'm sure the defense is going to have a great answer.
Because there are, I already made my issue or raised the issue about the May 10th
We'll get there specifically. Any others?
Yes. I would have to go through, I have gone through, but to go through right now, every specific part.
But
there's a lot that's being left out, and what's being left out are the statements where officers are telling her about what she needs to do in order to not have to go to jail, what kind of deals they're willing to make for her, what she needs to do and say, and that's not included. And yes, some of it.
Then why don't you bring her up as a witness, you dumb There is a way for you to fix this. You just don't want to do it. You somehow claim that it's the state not wanting to do the work, but you are actively saying, I don't want to do this.
She was cross-examined on, but there's a lot more statements like that she was never cross-examined on.
Well, that's a choice the defendant made, though. So here, in order for me...
The choice the defendant, a.k.a. you, Zelda, and Zelda doesn't like that. Zelda doesn't like hearing about her choices may not have been great.
To include additional material, there has to be some basis. Is it a Rule 106 request?
Yes, but in all fairness, the choice was made because that was all that she was questioned on in direct examination. Had there been a redirect back to where I started, then I would have chosen other portions, but I have lost the opportunity to do that.
No, you haven't. You can...
You haven't, but that's okay.
Well, respectfully disagree, Your Honor.
Can certainly have access to this witness.
Well, I think
she's still under subpoena.
We've made our record on that.
Are there Rule 106 portions you want to add, having reviewed the designation?
I think we need all of it. I think the jury needs to see exactly what her demeanor is, how she acts.
I think we've got about 15 minutes left. Maybe less, actually. 10 minutes left of video.
With the officers, how the officers treat her. There are numerous other parts of this transcript that may come in through Detective O'Driscoll. I don't know yet. I mean, I don't know the answer to that fully yet, but there are a lot of other statements by both Detectives O'Driscoll and Detective Maynard that go to show that she was unduly influenced. There's a lot of it.
I know, but you're not giving me which ones they are.
It's because
it's a lot of it, Your Honor. It's a lot of it. Okay.
I mean, all of them.
Okay. All right. It's hard to rule on because it can't be all.
We don't have the references because we haven't really looked yet.
Why not?
Well, certainly your position isn't that every single statement made by the law enforcement officers and every single answer is evidence of undue influence.
Exactly right, Meow.
It shows an arc.
That's the state's point.
Right. I know. And now if we're going to do part of it, then we need to show the whole arc.
That's not how Rule 106 works. I need you to...
It's not how that works, ma'am.
Be more specific.
I don't have specific outlines right now in the 1,000 pages of transcripts as to what we would want and what we would... I mean, we want all of it. If you want...
Remember last week, ma'am, on Thursday, when this came up, and you said there's 1,000 pages. We can't possibly go through all that right now. Well, it's Tuesday, Thursday, Friday. There was no court. Saturday, Sunday. Friday, Saturday, Sunday, at least there was no court. That's 3 days. Good Monday.
I'm going to go through all 1,000 pages again and try and figure that out. I mean,
again? You're going to go through it again? I mean, you didn't take notes the first time? Just plug it in ChatGPT, all that. You'll be fine.
Guess we can find some time to do that, but...
Okay. So, Mr. Bloodworth, as for today, how does the state...
Probably would have been helpful to do that originally before the trial started, when you were preparing. Since you called this their star witness, wouldn't you have all the episodes of her being coached and influenced, if not tagged in a printout with little sticky tabs written down?
Proposed to proceed.
So I propose we call Chris Cotodemos. I then will call Jeff O'Driscoll. We will get to maybe, 45 minutes into his argument before this will become an issue. Okay. My sense on timing, Your Honor, is this doesn't become an issue till a lunch break.
I'm not sure what's going to change between now and then, though, in terms of the issue of whether to play everything or just the parts that the state has designated under Rule 801D1B.
Fair.
So, all right. The issue before the court
Judge. You think trial's happening today?
The state's motion to admit redacted exhibits 8-57R through 8-63R. The state is offering what it views as narrowly tailored portions of the transcripts of Ms. Lauber's prior interviews with law enforcement investigators and other government agencies as evidence of prior consistent statements by Ms. Lauber under 801D1B to rebut an express or implied charge that when she testified in open court in this case, she acted from a recent improper influence or motive in so testifying. In response, defendant does not provide a sufficiently specific argument that the state has over-designated any of these portions beyond what would be permissible under 801D1B.
Yeah. So I guess defense loses there. Human 2 said, did they not go through all 9 interview transcripts in their binders with Carmen on her cross? Well, they stacked them on the stand. And they read enough into, they read the first couple pages and they're like, okay, sticky note here, and they're jumping all over in terms of the dates, trying to confuse her. Okay, so the judge just ruled there's not an issue with 801D1B for what the state wants to put in. And then based on Robin's comment that the defense said there's no issue, it would seem like they lost, or not lost, that like this is stupid.
And though defendant makes a Rule 106 argument regarding additional portions that would be necessary to provide context for explain.
Suma says, what's crazy about them wanting to question Carmen again is that it made them look terrible the first time. Well, no, they don't want to question Carmen because I'm pretty sure they know how the internet reacted to it.
In court in this case, she acted from a recent improper influence or motive and so testified. In response, defendant does not provide a sufficiently specific argument that the state has over-designated any of these portions beyond what would be permissible under 801D1B. And though defendant makes a Rule 106 argument regarding additional portions that would be necessary to provide context for, explain, or qualify Ms. Lauber's statements, their position is that all of it does.
Which is extremely stupid. What parts help clarify? It all of it. Even the stuff which doesn't make sense, literally, logically. The prosecution is trying to put parts of it, and you're saying all of it helps prove that she did lie. Well, then that would include the part that the prosecution is putting in. Morons.
And that does not provide the court with a sufficient basis to rule one way or another whether other additional portions of these prior interviews are required to be included under Rule 106. Based on the record currently before the court and the procedural posture that brings us to this point, the state's motion to admit redact exhibits 8-57R through 8-63R is granted to the following extent. The state may publish these exhibits and use them with witnesses that are on the stand. Sitting here today, the court is not prepared to rule and does not rule that 8-57R through 8-63R may go into the jury room as admitted exhibits under Rule 17K because, sitting here at the moment, the court determines that they should not, in the opinion of the court, be in the possession of the jury to make absolutely sure that the jury does not give undue influence to these specific portions of a single witness's testimony as compared to the testimony of all the other witnesses in this case. Mr. Bloodworth, anything further on that?
No, Your Honor.
Yes, Your Honor.
Okay. You just lost their defense.
I cannot fail.
We actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions should be let in. If the court's not inclined to let all of it in, then we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
Wait a minute, ma'am. Wait. You are saying that there are specific things that prove that she's a liar. Yet you're saying now we need 2 days to go back through the testimony to find out what those statements were. Why don't you have those written down? Why did you not have this prepared in the months leading up to this trial? Years. This is insane. A 2-day recess?
2 days.
Yes.
Your request for a 2-day continuance is denied. I don't have a basis to use that much time of the jury when this motion was filed 2 days ago and I raised it with you yesterday.
Okay.
Your request for a 2-day continuance is denied.
All right, a 1-day continuance then?
To tomorrow morning.
Yes.
And what is it you're going to do between now and then?
I guess we're going to go through the whole transcript and find out what we want included under Rule 106.
And you're going to file something so I can read it?
Yeah. Yep.
Mr. Bloodworth.
Your Honor, the state objects. Not only did the state file the motion 2 days ago with the specific portions, this whole issue was teed up last week when Carmen Lauber.
Judy Tester has been hidden. I don't know what her deal is. I mean, we get the trolls. Like what I'm saying. Racism will not stand on this channel unless it is a very funny, what's the word? Stereotype that isn't actually motivated by racism. Okay? And we're definitely not going with the hard R on this channel, please. But what I'm telling you, what I've seen in these chats, the more this case goes on, these trolls are showing up. I don't understand the motivation. I think it's just to get all of us to hate each other somehow. But
testified. I don't think there were any surprises in the motion, and I think the state's motion and the redacted versions it filed were probably what everybody expected.
All right. And Ms. Lewis, you'd be filing something in writing that had additional either Rule 106 inclusions or some identification of where the state has over-designated things, correct?
Yep.
And your position would be that additional parts of the transcript should be...
But again, remember, times will be able, only I may ban somebody, which I did.
...shown to the jury, is that right?
Yep.
That is so slow. There's just no way this is going to work.
Oh, Zelda
that had additional...
Zelda doesn't care. It's your problem, Judge.
Either Rule 106 inclusions.
Billie Jean was upside down and backwards.
Or some identification of where the state has over-designated things, correct?
Yep.
And your position would be that additional parts of the transcript should be shown to the jury, is that right?
Yep.
Watch Zelda's reaction here.
That is so slow. There's just...
That's your problem, Judge, not mine.
There's no way this is going to work. There's no way we can edit the video.
I'm not tracking, Your Honor.
Each of these transcripts corresponds to a video of an interview, correct?
Correct.
They were using hard R and all of their, hard R N-word. What the hell? Yeah, no, I'm fine. It's fine. Time me out, but let me know so that I can then ban them. Like, let me see it beforehand. I just happen to see it.
It would seem that watching and listening to the video is more efficient than reading the transcript.
100%. Your Honor, based on the ruling right now, like 2 minutes ago, we have launched our video editor to create the video now of the narrowly tailored portions. That's how we would publish them.
You don't need a video editor. Contact me, bros. I can do it for you. No, Kouri isn't paying your attorneys anything. These are all being paid by the state.
It is by playing the video.
Okay. All right.
Yeah, it's fine for everyone. I'm not judging you. I'm just saying just hiding them isn't effective enough because if they're doing that, adios.
One suggestion could be if the state wants to hold off on publishing all of this and see where they get with their testimony of Detective O'Driscoll, and maybe through appropriate direct examination, they can get in the portions they feel are important, and then maybe none of this would be necessary if that decision could be held off. And then if at the end of the day they still want to publish the whole thing, then we would ask that we not hold court tomorrow so we could do that. I think that would be more efficient.
Maybe.
Your Honor, we're going to want to publish it. Let's just cut to that chase.
All right, folks, give me 5 minutes. Actually, just give me till 11.
Make sure my cup's showing my last name
We're
here.
Recess. Ms. Lewis, the defendant asked for a 1-day continuance to allow time for defendant to, on the one hand, review the designations made by the state, determine whether there are some over designations that go beyond what should be published under 801D1, and also to offer additional designations that in the defendant's view should be included under Rule 106. That request is granted. We need to come up with a set of deadlines by which defendant will take those positions in writing, by which the court and the state can review them, by which we can have a discussion on the record about which of defendant's positions are persuasive. And if possible, Mr. Bloodworth, and I know I don't have any control over this, I'd really like to build in time for the state's video editor to take whatever I decide and turn it into a video so that when we're publishing a video, not just pages of a transcript. Let's work.
Snowcat says this defense spends so much time making Eric look bad, making Carmen look bad instead of doing the job. And it's ironic because remember in their opening statement that, you know, they're going to try and make Kouri look as bad as possible. They're going to spend their time smearing Kouri. They have done very little to smear Kouri. They have just shown what Kouri's done. Human Tooth says, you just described half the chat. I think the numbers came after recent updates for names that were common. Well, I think always the names were there. Now it's just... I've no problem. I've never seen your set. What do you think? A setup? Setup? No, she did it. She totally did this. And I think the extra characters are added when there's a common name, which makes sense. The dash, though, I think is auto-assigned. I don't know. But I will agree with you, Nunya, that most of the people I see in these chats where they're just off the rails, like just spamming all caps, being like, oh, the judge is so biased. Oh, the defense is cooking this witness. Oh, the defense are cooking. The defense are cooking. They all seem to have that extra hashtag on there. And Suma says, yeah, they put four digits after every name, right? Because it's randomly generated, right?
Backwards from there. Mm-hmm. How long is that process? And if you need to.
Oh my God. And now we have Whitney Marie, 4007. Even right now, 6846. Just kidding.
Take a moment, step out, tell your video editor to press pause. I'd understand.
So the state will, within an hour or two, maybe within 3 hours, have the video that corresponds to the status quo of the 6 exhibits.
Understood.
Now, depending on how much additional comes in and how much additional goes out,
right.
It's hard to say. 4 hours.
Okay. As a practical matter, do you think we should start midday tomorrow or just come back on Thursday? I was hoping to start midday tomorrow.
So we can do that, assuming...
All right, so that's basically it. What they're going to do is they're doing they recess until tomorrow. Where's my video? Where am I? Where am I? They recess until tomorrow. They're going to be there earlier. The jury doesn't have to show up till 1 o'clock because apparently, well, actually, no, I got to get back in because I did miss something here because they were bitching about the amount of time they had. Let me play that.
Was the court considering a deadline from defense something like 6 p.m. today?
Yes, something like
if we get that at 6 p.m., my sense is by 8:30 tomorrow, the state will have a response. The court rules by 9:30. We can probably get the video done.
Okay.
We're just discussing. I don't think we can get it done by 6.
I don't understand why. I mean, the transcript is only this much stuff printed in 12-point font. But the Rule 106
I don't know who
designations would be immediately before or immediately after. And to the extent you're going to de-designate, you're just taking stuff out.
I don't know if... Sorry, Michelle DeMattis saying Nunya is Josh. Josh, please stay away from Lauren. Like, Josh isn't like Madonna. It's not very unique. I don't know who Josh is. But... You know, if you follow Signature Crime, that's probably why I clicked on my thumbnail.
Of those, so it's a relatively focused inquiry. You can go back and watch Carmen Lauber's entire crime.
Oh my God, West Coast Crime Fighter, another 4 digits. Is it Josh Grossman? Nunya, are you Josh Grossman? That doesn't make sense. You're telling me Josh Grossman is in the chat right now. Nunya, are you really here? Josh Grossman? I have so many questions. Josh. No, I don't think it was a setup of Kouri. I highly doubt that it's Josh Grossman in the chat here. Finger red number 1. I think there's more going on here than meets the eye. You ask away. I'm not sure that Josh Grossman would be in my chat. Why would they waste the time? There's not more going on here than meets the eye. This is as simple as anything.
Direct and cross on court TV at 1.5 speed to refresh your recollection of what she said on the stand in order to determine whether this is consistent or not. To the extent you
Nunya, aka Josh, why don't you tell us what's going on if there's something hidden? Because more than meets the eye going on here, that sounds a lot like the defensive strategy of, well, you never know.
Want to get more beyond this. I'm not sure you're entitled to do that.
I don't understand.
Well, if, for example...
Again. I don't understand.
There's 200 pages of interview with Jeff O'Driscoll the first time.
But Nunya, if you are Josh Grossman, you want to come up and do an interview on this channel, my email, it's in the channel description. I'll put it in here again. It's JustHearMeowt, spelled out, not like the cat, 2023 at Gmail. Email me. You can come up. I'll have you on. It won't be a gotcha thing. I don't have a problem with you, Josh. I'm just curious what you're saying. I don't believe that Josh would be in my chat.
State's just trying to put in.
But if I see you on camera, I'll believe it.
From the beginning. You don't get to skip to the end and say, well, these last 40 would be really helpful to us. We made a strategic choice not to ask Carmen Lauber about them when she was on the stand, but we'd like to put them in now. That's not this exercise.
I'm not sure I understand what you mean. The portions of the transcript that they pulled out are from portions of all 7 interviews.
I agree, but they're not. They're just portions that are prior consistent statements. And so did they over-designate? This goes beyond a prior consistent statement. Or is there some stuff immediately before?
Yeah. Exactly. Candace says, Josh, if you do an interview, do it here. Hidden true crime exploits people. I don't exploit anyone. I'm doing this for how to make $23 a day.
Or immediately after under Rule 106, that's required to
this
qualify,
is a
provide context, or explain.
Your Honor, can I add a small wrinkle to that?
Sure.
In addition to prior consistent statement,
got it. Forever wonder.
Rebuttal on reason motive to fabricate.
Yeah, that is the same. That's the prior consistent statement.
I think there were 2 separate things in 802D1, but maybe we're saying the same.
Okay, so we got through it where they're complaining they need more time. And the judge is like, no, I need to be able to review your motion. The state needs to be able to review your motion. Well, did Josh leave? I put my email in the chat there. Here, look, I put it on screen again. Josh, this is my email. Where is it? But out of respect for Josh, I'm not going to just claim that somebody is Josh. If they show me they're Josh, then I will represent that they're Josh. But I don't know who you are if you're not Josh, and I'm not going to say that you are representing what Josh would say. If that makes sense, Nunya. So, Nunya, my email is on the screen. Yeah, Josh didn't kill anyone. I don't have a problem with Josh. I thought Josh's testimony was great. Fairly sure I defended Josh. Anywho, we're going to end this with another replaying of that clip from the day 10 recap. I can't talk, bro. I just wanted to see your show. I'll write your email down. Appreciate you keeping it real. You can't talk because of the court case. I just need some proof that you are who you say you are, even if it's a picture of you holding up Just Hear Me Out or Hear Me Out on a little card. That'd be enough for me. Just so I just have to verify who you are. Because like you would want, if you are Josh, you would want me verifying who you are before I say Josh said this, right? out of respect. Okay, so thank you everyone here. Sweets forever. He's not going to get these jokes. Josh, kiss your finger. Everyone needs to kiss their finger and delete their archives. Yeah, I would not do any interviews over there based on like what I've seen, what they're representing. It is so frustrating hearing Lauren Mathias and her husband. Again, the reason I don't like it when I'm watching them is always seems like they are about to make out. Like, oh, honey, oh, you said that? Oh, like they're in an intimacy session, which is weird. They constantly hammer the allegedly. Why not just say what you think she did? Right? This neutrality, based on what we've seen, doesn't make sense. Oh, okay, you get it. You might be called up again. Got it. No, but what I'm saying, Nunya, at least send me a picture with "Hear Me Out" written on it, and I can see your face behind it. You don't have to do anything else, so that I know you're actually who you say you are. Just like I have Suma send me a picture with her with the newspaper every day, every morning, and she starts it with saying Waldo. It's like Jamie with Lauren. Yeah, to my email. Yeah, just send it to the email. And you're welcome back anytime here. Doing this every night. So, with that said, everyone, thank you for being here. Thank you for hanging out. Remember to delete your archives. Kiss your finger. Bye. We were talking about the fat activist who got arrested at the hospital. Remember that the woman who was like 800 pounds? Like,
yes.
And she's like, rape.
Yeah, they have to like, I don't know. She was just
she's
on a tarmac for like 3 hours.
I said, if I ever start making quote body positive end quote content, mail me a hand grenade with the pin without the pin. And then you followed it up with actual LOL. And then I said, if I ever start rating different rascal scooters, mail me some high quality anthrax. Oh, thank you for reminding me of that.
Yeah, thank you for finding it.
Yes, that is my testimony on direct.
Okay. Now let's go to the one of the safe. Can you pull up the clip?